me to Kasab. What do I have to do? I was a sitting MLA.
Nothing. You have to seek an assurance from the court of law that irrespective of the nature of allegations, irrespective of anything coming in media, you are entitled to a dispassionate hearing of your criminal appeal by the High Court, which will be decided without being influenced by here and there anything, which should strictly confine to the evidence on record, material on record. That's all.
So now, may I just answer one question which fell from my Lord Justice Bagchi. My learned friend says he has filed an appeal. That appeal is for necessarily enhancement of sentence. It can't be for anything. It has to be enhancent of sentence or change, or that it goes under 302.
Why not? Why not? It's 302 charge was framed against you. 102. 300
Assuming against myself.
So there is a lesser offence on which you have been convicted. Why so to the?
Just bear with me for the submission.
Yes. You can bear with you for a lifetime, Mr. David.
The enhanced sentence could also be death in that.
May I just indicate why I am making this submission? If it is my learned friend's appeal, it goes to DB. This matter is before a single judge. It's below 10 life sentence. Then it cannot. No, I'm saying if it is fixed on 11.
In appropriate cases, Mr. Dave, this sort of an appeal where there is a possibility of an appeal by the victim for enhancement, not a case for a division bench.
So there's no point, for 11. Nobody is arguing this. I don't know why the solicitor has not preferred any appeal in this matter. The CBI is sitting pretty.
This is not a case of any quorum non judice plea. These are all internal arrangements by the.
Are asking the High Court to expedite the appeal.
So therefore, in the case, suppose a division bench of the High Court, suppose prima facie feel that the appeal filed by the victim also should be heard along with your appeal. In that case, matter has to be listed before a two-judge bench.
So it can't be heard on the 11th in any case. Since much submissions were made, it's listed on 11th, hear it on 11th, have it on day to day. The other side is saying, though, it can't be heard. That's what I'm all pointing at. The only thing I was pointing out.
Can be taken up on some other.
So, Milords, 10 years, assuming that he goes through his 10-year sentence, Milords, his appeal would be infructuous. And if their appeal is dismissed, he's undergone the entire sentence.
Kind of whatever doubts you have in mind about listing, that we will clarify here. Both sides.
Saying, if
both sides are present before us, so
in 9 months, 7 months are not enough. If 9 months, 7 years are not enough,
as well as their.
We were not even charge sheeted for murder by the CBI. It was a club trial, therefore.
We are not charging.
Look, may I just say for the initial third, this.
So I'm only saying, my lords, 9 years, 7 months undergone. With remission, another 5 months I have to undergo. I will undergo that period. There is nothing else that is left. Whether the appeal is heard or not becomes an academic question.
No.
Only if their appeal gets allowed.
There is no criminal appeal becomes an academic issue. Even in those cases where unfortunately the persons died while pending the criminal appeal. Because the family is still entitled to seek vindication of innocence. If there is an innocent person falsely or erroneously convicted by the trial court. So these are nothing to do. Completion of sentence, anything. These are not the circumstances.
Out of 10 years, 9 years, 7 months in custody, or 7 years actual custody, is more than 7 years.
We appreciate your contention. Therefore, request the High Court. Request the High Court to decide your appeal.
If I had come in any ordinary case, Milords, I would have got bail. With respect, I'm just saying so, Milords. When it came, the other matter came before your
jail for
last 1 minute. My solicitor is not. There is no notice is issued in this matter. Now, because that other matter, when it came, we said that this is. It fell from the Honorable Chief Justice that you are not released in that matter. Therefore, we are staying that matter, in the bail in that matter. When we come in this matter, the solicitor says, in that matter, you are in custody. So how does it matter? Somewhere I have to start getting bail, or I'm going to be just in arguing my appeal or pursuing my appeal. And now the complaint.
We have already explained that in a case of conviction
On merits also.
and pending criminal appeal, what are the parameters normally we follow on uniform basis in all high courts and including the Supreme Court.
Yes.
Where the accused is inside and has not been released on bail, he or she is entitled to an out-of-turn hearing of the criminal appeal,
yes,
so that at least before completion of the sentence, the matter is heard. That is the principle followed. In your case also, there cannot be any exception. You are entitled to whatever you are entitled to law, you must get it. Yes. Therefore, you are entitled to an out-of-turn hearing that the High Court is according. We will also make sure that you get it.
But that process is not available, my lord, because now the complainant feels that I should be convicted under 302. So his appeal first has to be
Mr. Dave, for
365.
for deciding
now
your
365.
for deciding your appeal, we cannot gag the right of a victim, if at all there is a right in law.
Mine also, my lord.
Yes, therefore balancing has to be done.
For 9 years, 7 months,
We are absolutely right to do, but there has to be a balance of rights.
I've undergone more than half of this actual sentence. Actually, I've undergone more than half, my lords. Kindly consider this. In which case, for term sentence, this is not a life imprisonment. Life imprisonment, I can understand the High Court has some leeway. Your lordship may have some leeway that it's a life sentence. There is no term there. But in a term sentence, my lords, your lordship always takes into account the period.
It is a term sentence of a person who has been convicted and sentenced to life imprisonment in another case.
Yes, my lord.
Isn't that a relevant consideration for
Because it is in
suspension
that
of
when
sentence?
that matter came up, my lords, the same argument was there that please stay.
Really, one will color the other.
So, my lord,
If there are,
That's what I'm saying.
why do we speak of criminal antecedent? When it comes to a question of multiple cases against an individual, courts are generally circumspect in granting
same incident.
pre-conviction bail.
Same incident. It is not a separate.
No, it's definitely not the same incident.
Exactly.
It's the
same
motive.
incident.
It's the motive.
Allow me to.
The rape case is the motive for this crime.
In this case, here the person died in police custody. Person died in police custody. I was
Two
talking.
police officers have been convicted.
Yes, my lord. And I have been with 120B. I was in Delhi. Those are the findings. I can show
Let us not comment on the merits.
Mr. Dave, any argument touching the merits from your side will invite a reaction from our side unnecessarily. And you know this matter that unfortunately it's not that we are not sitting in ivory tower. We know that there is a media trial also going on, which we do not really approve. And the way Mr. Prachap outside the court, he goes to the media. If you are a counsel, you have no business to go there. Don't forget, I have saved you in profession. Your license would have been suspended. Your exemplary costs were imposed on you by the High Court. I saved you thinking that you will believe in professional ethics. You have no business to go to media when you are appearing in a case here. If you find that you are indulging in this kind of drama, then you will face the consequences also.
Can I just say,
As a Chief Justice of India, I can't tolerate these things.
let's kindly see what the other side.
You are arguing here, you are conducting a parallel trial outside the court. This is not acceptable.
I was just informed.
We are only warning you today. You take this warning in the right earnest. That's all.
Can I also say this, that please tell this to the other side also.
Right now.
What
They have
side? I never went and gave interview in the
Now
other side.
we have conveyed our message, and anybody knowing that how I function, I hope that people will believe it and follow it.
May I just say
Then may I only suggest,
Do not invite any
let the
consequences. That's
DB
all.
take a call whether his appeal is maintainable or let the
the
DB.
other side also.
You have a right to oppose. He has a right to
No,
argue.
I'm saying let the
You will argue in court. That's all.
because the division bench, since your lordships are asking for expeditious, let the DB first decide whether his appeal is any merit in it or not. Then call for my appeal.
The way that he will argue before division bench of the High
Believe
Court,
that-
not before us.
Expedite, then I'm only praying don't expedite this simpliciter, my lords, my matter. Because
All
it will be tied up with the division bench matter.
Right out. The petitioner, Salim granted, the appellant is agreed by an order dated 19th January 2026, passed by the High Court of Delhi, declining his prayer for suspension of sentence and consequently release on bail in criminal CRLA number 539/2020. The declining his application under section 389 in bracket 3 CRPC, seeking suspension of sentence and so on. The above stated criminal appeal has been directed against a judgment dated 4th March 2020 of the trial court, by which the appellant was convicted for offences under sections 166, 167, 193, 201, 203, stroke 21, stroke 21, 212, stroke 323, 341, 304, 120 capital B IPC, and sections 3 stroke 25 of the Arms Act. We just make sure that correction in this section. He was consequently sentenced to undergo a rigorous imprisonment of 10 years.
Yes, my
10
lord.
years.
Highest is 10 years amongst all of them. The highest sentence amongst all of them is 10 years.
Terms, maximum of which
He
was
was a maximum tenure of maximum RI for 10 years, though different sentences were awarded for different offences. Those separate sentences were awarded for different sentences, offences.
And all directed to run concurrently, my lord.
Next paragraph. It seems that the appellant, besides arguing, besides making an attempt, a case for suspension of sentence and release of bail on merits, also vehemently urged before the High Court that he has already undergone an actual sentence of 7 years and 9 months out of the total sentence.
With
And-
remissions. With remissions.
7 years, 6 months, 29 days with actual. My learned friend is not aware since I'm in custody, and 9 years, 7 months with remission. So 7 years and 7 years and 7 months of actual custody.
7 years or 7 months of actual sentence. Anyway, that's a matter of calculation.
No, it's there, my lord, at
Next paragraph.
46.
The High Court has wide impugned order one more line. The appellant also urged that some of his co-accused had already been released on bail after suspending their sentence. Wide orders dated 22nd September 2023 and 17th October 2023. The High Court, however, wide impugned order has declined the suspension of sentence and consequential release on bail, entirely observing that the appellant is already serving a life sentence for the rape of the deceased minor daughter in a connected case, semicolon, that his previous application for suspension of sentence was dismissed on 7th June 2024, and there are no new exceptional or compelling circumstances, etc., etc. Next paragraph. The aggrieved appellant is before us. Next paragraph. At the outset, it is pointed out by Sri Tushar Mehta, Solicitor General of India, representing the Central Bureau of Investigation, that criminal appeal, criminal LA number 539/2020 of the appellant's criminal LA number so and so is now listed for hearing before the High Court on, what is the date, Arvind?
11th.
On 11th February 2026. He thus submits that the High Court can be requested to take up that appeal, to take up and decide that appeal on out-of-turn basis. Can may be requested to take up and decide that appeal on merits, on out-of-turn basis. Next paragraph. At this juncture, counsel for the
Complainant.
victim states that the complainant side has also filed an appeal challenging the trial court judgment dated 4th March 2020 on various grounds, including on the question of quantum of sentence. Next paragraph.
Pending before the division. Which is pending before the division bench.
Since there is no reference to that appeal in the impugned order of the High Court, comma, we do not express any opinion in relation thereto. Next paragraph. Keeping all the attendant circumstances of the case, comma, especially the period of sentence already undergone by the appellant, comma, we deem it a fit case for requesting the High Court to accord out of turn hearing in criminal LA number 539 of 2020 and decide the same as early as possible, comma, but not later than 3 months. But not later than 3 months. Next paragraph. As regard to the criminal appeal, comma, if any, comma, filed by the complainant party stroke victim, comma, we grant liberty to the appellant in that case to approach the High Court for taking up of that appeal to for hearing. Full stop. The High Court is requested to firstly take up that matter within a 1 week and subject to the objections re maintainability, etc. Comma, if the High Court find that the said appeal to
What issues can be decided together?
re maintainability, etc. Comma, it will be in the interest of justice that both the appeals are heard and decided together. Heard and decided together. Full stop. If such a recourse requires the change in composition of bench for for deciding criminal LA number 539 of stroke 2020, comma, Honorable Chief Justice of the High Court will do the needful in this regard. In this regard. Anything else you want?
There are 8 connected appeals which have to be decided with this 539 of 2020. They are all co-accused. So it's not my appeal. There are 8 connected appeals.
Connected appeal of other
With 539 of 2020, the present appeal. So they all have to be decided together.
If there are, next paragraph, if there are other connected appeals, those two also be taken up and decided along with the lead appeal, along with the lead case.
Then if it is not decided in 3 months, my lords, then where do I go?
Yeah,
So then I'll be back for...
Incidentally, I am not retiring in 3 months. My brother or both in any case will retire after me. So there nothing is that unforeseen circumstance we should see.
I have hope, my lords, to be back before your lordships. Grateful.
Milord, bail matter. Trustee also.
Issue notice.
Advance.
Would you like to accept notice?
Accepting.
Then so accept notice. Counter affidavit if can be filed within 1 week. Counter affidavit only 10 days.
2 weeks.
2 weeks. 2 weeks post the matter on so date for further consideration.
Get me the...
Will be question is we may have. 23. Any comment? Twenty-three. We just follow 23. Lordship, it's specifically refer for the prayer.
This writ is not maintainable. Kindly have the prayers, my lord. If he has a grievance, then he can approach the High Court, my lord.
Uniform standard operating procedure governing pleasing.
And that is already on.
The accounts having cyber crime investigation. How can such a direction be issued? Sir?
Lordship, the thing is, after the last
It has to
order,
be decided on case-to-case basis.
Lordship,
Where we find that yes, freezing is absolutely unwarranted, we can go, the court can interfere, and why should we entertain this?
Lordship, there is a subsequent development after filing of this order on a 16 January of the last order. Delhi High Court also issued this similar.
That matter is also today.
That's a suo motu petition.
So is it listed today?
Yes.
Okay. We'll hear it up to you.
Yes. Lordship, just consider the order passed by the Delhi High Court in a similar matter, where the Home Ministry come with the standard. They've already issued some SOP. So if SOP is there, then just let it be.
High Court of Delhi High Court judgment before us.
My lord, I am also in the matter 47, similar matter, my lord.
And then one more part.
Judicial High Court is UP, my lord, Allahabad High Court.
My lord, these accounts are being frozen across the country, my lord, and there are so many matters.
Because
And there is urgent need, my lord, to intervene and
You
to.
want us to uphold this freezing of accounts? You want
No,
us
my
to
lord,
uphold?
I am saying
Don't invite further
unfreezing
trouble.
should be a mechanism, and 106 is being violated, 107 is being violated. Magistrate order is required, my lord.
Having heard and consulted.
Kindly issue notice in this matter. This is very urgent, my lord.
Judicial Solicitor of India on behalf of correspondents, Union of India, we see no ground to entertain these petitions.
Multiple states are doing in the same account, my lord.
Accordingly dismissed, however, with liberty to the aggrieved persons to approach the jurisdictional high courts on case-to-case basis.
Lordship, before concluding my.
No,
I
that's
just
no
want to
question.
point out one thing.
Everything coming under 32, as if there is no other.
This is being misused by the law enforcement authorities quite a bit.
Absolutely.
Kindly, it is
I
required, my
find
lord,
that they
to.
must do something very.
I am in Mumbai. My account is frozen for
That's
4,000
the
rupees from
difficulty.
Jammu Kashmir, my lord.
Then go to High Court, approach the High Court.
So that's
Do
the
not know.
concern of the entire petition, that if I'm standing in.
There has to be
Andhra Pradesh,
proportionality, my
then
lord.
Complaint filed before.
Every person like this start coming in the 32, what will be the end?
More than
High Court,
multiple
you
states
cannot remedy
involved. My lord's intervention and the law has to be settled, my lord.
We will, don't worry, we will do that. We are right now.
Kindly issue notice and
Sorry.
allow us some relief, my
No
lord.
question of issuing notice in these matters. Where you are suspected to be involved, where is the question of issuing guidance at your instance?
47, this is my customer. It's a consumer matter only, 4,000 rupees.
Yeah, thank you very much. Thank you.
Kindly have a look at page 60. Just 1 second, my lord.
If you don't see anything, please go to High Court and show
It
it.
will be,
Go to
no,
High
my
Court
lord,
and-
can give, just see my customer is there.
Yes, yes.
And they are misusing this. After 8 days, they are filing this complaint.
Customer, the banks are hands in glove. This is what the report shows. We don't want to say anything because it will cause serious prejudice to all of you. The banks, their officers are hands in glove in the matter of digital arrest and the cyber crime of looting this money. It's not extortion. It's a
My lord, but I am suffering.
brazen loot.
Yes, Lordship.
Bank might be involved, but I am suffering, my lord.
Lordship is absolutely right.
What
There is
can
a
we
bank
do?
are involved, but in this case, those are not directly compared.
Please go to, that's why you said case to case basis. If you are a victim, you will tell the court. If you are
concern, Lordship.
if you are clean hands, you will tell the court that I have nothing to do with, court will pass an order.
We are not concerned with the transition itself.
Thank you very much, thank you.
Lord, there is no FIR, nothing, just the misuse of the I4C mechanism.
Yes.
Kindly issue some guidelines on this for the defreezing, my lord.
We will not issue right now, we will see at the time of final hearing.
And my entire business is gone, my lord, because my account is completely frozen, my lord. I am a small time professional
Therefore-
operating out of
therefore,
Mumbai, registered with SEBI,
Yes,
my lord.
item 24. Lunch. Yeah,
May I request that 24 may be stood over?
that would be the no.
Look, may I request that 24 may be stood over to tomorrow or any other date? There was some misunderstanding. I thought this was the matter where notice had been issued and
Next Monday, Mr. Singh.
there was some miscommunication on my part. Can I request if your lordship?
No, you wanted to place on the additional
We
document.
placed those, but I thought this was the matter where notice was issued. I mixed it up because no reply was there in that matter. So if your lordship could keep it either tomorrow or Friday, or whichever date your lordships.
Friday, we are avoiding Friday.
Or Monday, there was just some miscommunication on my
If you
part.
want to next Monday, we can take.
We have already filed the documents. I had some misunderstanding about which matters listed.
We will say like this.
Monday, if your lordship would keep it.
Mr. Singh and Senior Counsel informed that additional documents have been filed. The registry directed to tag the same, post the matter for further consideration on Monday.
Deeply blessed.
May it please, my lord.
Item 26,
26, your lordships have already,
we will allow that matter. Huh?
despite your lordship's order, every day they are filing
They are
cases.
still
in
filing.
Calcutta, my lord.
Then if we issue notice and you remind us, then we'll impose some exemplary post.
I'm grateful, my lords.
How much the amount in dispute?
My lords, the loan amount was 1 crore, out of which we went to DRT and we paid substantial amount.
Issue notice to the respondent returnable on so-and-so date. The respondent bank will also show cause as to why contempt of court proceeding and exemplary fine cost be not imposed on it for filing complaints at.
I,
The complaint has been filed which place?
my lords, Calcutta, my lords.
Huh?
Calcutta.
Has been for filing the complaint at Kolkata instead of Nampally,
Hyderabad.
Hyderabad.
Correct.
Basti.
Till then, the proceedings may be stayed, my lords. Till then, the proceedings may be stayed, my lords.
You serve them next week. What is the next date?
My lords, the next date I have to verify, my lords. I have to verify.
Meanwhile, further proceeding before the Calcutta so-and-so shall remain stay.
I'll do that service, my lords.
Item 48.
Grateful.
Yes, my lord.
Huh.
My lord, may it please your lordships.
We will take up along with those matters. We will take up along with other matters. Everybody now start filing separate cases. We will take up along with the other cases. Coming 2 o'clock.
Bharat. One matter, Manora speaks today as item number 36, where the Calcuttahighcourt directed the tribunal.
Wait for the turn, wait for this.
Can he take up this matter at any point of
We
time?
will see, we will see.
Yes.
Item 39 first, digital arrest matter.
Please, your lordships. I have got a brief note of lordships consideration.
Yes.
Just to give a status report on that, an update. May also hand over the complete status report.
That's me behind you.
Threshold of 10 crore may be on the higher side, Learned Attorney. Individual losses, the individual loss of 10 crore.
Yes. But then,
But then, you see, there are people, senior citizens, for them, any amount of running into few lakhs, particularly in a case like one of the retiree couple, where which prompted us to take suo moto. There the loss was 1 crore something.
that's right.
But so look at that, for them the entire life saving.
That's true. Nobody has any. The government is very keen. We should put all these schemes in action mode as early as possible. But unless we complete this exercise, it will be like working in darkness. So I think it
SOP initiative we appreciate. That's it.
the SOP in fact is very exhaustive, and there are some Rajasthan High Court and Kerala High Court. Some judgments have come. We are trying to look into them. As far as they can add on to the SOP, we'll try to add on to them. But I don't.
You can apprise us if the high courts are also entertaining. We don't want any parallel proceeding to come.
That's true. That's right.
That we can transfer those.
So the SOP as of now, I think, is fairly comprehensive. Let it take shape by giving, putting it in action mode. And therefore, your lordship to kindly, in terms of the status report, kindly turn to page number 9 of the status report,
Oh.
As of now, I think in view of the progress being made, this limited direction would suffice. I had a word with the learned amicus, and we value her input being given to the government, and she will continue to be associated with the deliberation. So page 9.
That's it.
This will go a long way in now trying to expedite the entire process of deliberation. There's also, I think, since I suppose the learned amicus would share her views with me, and we'll try to, I said, add quality by adding her inputs into that.
My lords, I have filed a written submission pursuant to the status report. I've tabulated, there are 2 status reports that were filed, one by MHA and the other by MATI. The first one being of 13/1/2026 and the second of 29/1/2026. I have tabulated it and I have shown what are still pending and that which has been addressed at least at a preliminary stage. And I'll continue to, I'm hoping that there will be cooperation from all the departments because, my lords, the status as it stands today and from the status report also is that every action that has been mandated or warranted by my lord's directions or as suggestions from all the stakeholders collated and submitted along with my suggestions are work in progress. So they have pointed to some of the actions already taken under various circulars, but there is not yet further action or suggestions on what is to be done next.
I think if the SOP is approved, then
Yes, the SOP is a
This
critical.
note,
Yes.
this note summarizes, I think, the ongoing deliberations and the time frame within which, kindly, if you lot kindly turn to in the 2-page note, there are 2 or 3 things which are essential before you go further. For instance, E. We have A, B, C, D, E. So RDV has drafted the SOP. Then E, Department of Telecommunications drafted the telecommunications user identification rule.
I think all the departments are now in
So
action.
these are all very important.
Well, all of them have come on board. RBI has still to have a meeting. They have not yet had deliberations with me.
SOP is by RBI.
They have mentioned it, but I have.
That's
not
right. And now
received
it's been
copies.
finalized. Now the SOP has been.
The only SOP I have is from I4C, which was prepared pursuant to the Chhattisgarh High Court's order. But that was also a preliminary stage and it has not yet been submitted before
What
the
we
Lord.
do is that this SOP, because the action is the essence of this entire, this to deal with this crime effectively. So we issue the directions to implement the SOP immediately. Meanwhile, you critically examine that is there any lacuna or vacuum left. And then we will request them to address that.
Attorney
SOP
General
is-
has, very fairly, I would say,
Taken you into confidence.
reached out and requested me to be
The
part of
SOP
the
is a product
deliberation.
of-
Oh, very good.
It would be my
Yeah, in fact,
That's very fair.
duty to contribute. I will be most happy. My lords, I would only want to put this first, and it's recorded in the meeting also, which I had attended. This is a consensus mediated process, and all the departments are coming on board keeping that in mind. There have been extensive discussions, they have been cooperating, but the only thing that I have requested, and that's what my note encapsulates, and that is that the action that needs to be taken pursuant to some of the lacunae having been pointed out. That still remains to be done, and some timeline may be fixed by which they will do that action. And that would also help us to then,
Timeline
for the departments to revert.
Reporting compliance, banks.
Now, if you'll also see this 2-page note, we have broadly hinted at what timelines are possible.
The matter will remain pending. Today,
My lords.
today we are at the stage of formulation of policies, rules or regulations.
My lords.
Once that is done, then definitely, and those are implemented, then we will have the status report with regard to that, what is the actual action taken at the.
Yes.
The government is very keen to expedite it as early as possible. There's no difficulty at all about it.
Say, in continuation of the previous orders, including the 16th December 2025, London Attorney General for India, Shri R. Venkatramani, London Attorney General for India,
Let me note.
Yeah.
has placed on record a compilation containing status report on behalf of the Ministry of Home Affairs, Former Union of India, along with documents R1 to R5. Annexure R1 is 2 copy of the minutes of meeting of the second meeting of IDC held on IDC is interdepartmental committee held on 2nd February 2026. Semicolon. Annexure R2 is a copy of the detailed inputs in respect of the submission of DOT. Semicolon. R3 is a copy of the detailed inputs and supporting material in respect of the submission of RBI. R4 is a copy of the input shared by Meet Y in form of status report. And R5 is a copy of the SOP for NCRP, CFCR, FRMS, custody and the restoration of money and grievance redressal. It is pointed out that after forming an interdepartmental committee. Don't say after. It is explained that an interdepartmental committee has been constituted. First, the Central Bureau of Investigation has identified the threshold of losses of rupees 10 crore or more for investigation of digital arrest cases. Two such cases have been identified. Three such cases have been identified in Gujarat and Delhi. And state governments have accordingly been asked to accord permission. So we direct the state of Gujarat and NCT of Delhi to accord the necessary permission within 1 week. Within 1 week. Next paragraph. It is pointed out that the banks are using their own AI/ML tools for fraud risk management. About 26 out of 53 banks are stated to have also adopted Mule Hunter AI. Most importantly, Reserve Bank of India and Indian Cyber Crime Coordination Center, Ministry of Home Affairs are in the process of finalizing MOU for sharing suspect registry data to enrich mule account detection tools in bracket preventive and responsive dash data for cyber criminals and mule accounts available. Recruitment helps black fraudulent transactions and to help in blocking fraudulent transactions. We will appreciate it. The draft MOU is finalized. How much, Learned Attorney, how much time it likely to take the MOU, this MOU?
It take about 3 or 4 weeks. 4 weeks time at least.
Is finalized within a 4 weeks or so.
4 weeks time.
Next paragraph. Similarly, RBI has drafted a standard operating procedure prescribing actions by banks for placing temporary debit holds on amounts, to prevent money mule activities and cyber-enabled fraud.
Next page. There are two SOPs if you lot will make. Yes. Yes. One you lot should notice in page 1 and page 2. J. Serial number J.
This is to be.
And that's what is referred to in page number 9.
So this D is to be implemented.
No, sir.
J has to be implemented.
The mule account money is kept.
The reference in page 9 is to serial number J.
There is no serial number J in this. Which one? Which one? This? There is no serial number J in this. This one?
CRP-CFRMS custody and restoration of money and grievance redressal has also been approved on 2nd January 2026.
Yes, and at page 9 of the IA,
We
the report status
consequently,
we request the court to implement that.
consequently, we direct that both the SOPs.
It's essentially MHA's SOP.
MHA. MHA is only one.
On J, sir.
MHA is only this one.
No, MHA.
Okay, this will comprehensively address because some high courts have issued some direction. Rajasthan High Court. So this takes care of all that.
So people.
What I suggested to the
SOP at serial number, MHA's SOP is only serial number J.
that's right.
So, we accordingly direct the Ministry of Home Affairs to formally adopt and implement the above stated SOP dated 2nd January 2026. And the same be issued across the country for adopting a uniform process to strengthen inter-agency coordination, to ensure the timely restoration of defrauded funds wherever possible, and enhance
By all the participants.
Say that. We don't know which high court. There's only one concern, because people go to high courts. High courts have been issuing some direction, they also frame some guideline. Therefore, let this order be sent to all the
First, Mr. Attorney, we give directions to the participating entities, that
Correct.
is your police, banks and financial institutions, as well as the adjudicating authority.
That's right.
Under the auspices of all the high courts. Because they have to frame their rules. Some of the high courts have framed rules
Very right.
that without registration of first information report, also the attached money can be released.
Absolutely. But I thought in case people go to any high court need not undertake the exercise all over again and frame guidelines.
for adopting by all the participating entities a uniform process to strengthen inter-agency coordination,
Including the adjudication.
direction to the High Court and High Courts. This will add in the next paragraph, the High Courts. All the High Courts will ensure
That the adjudicating authority.
adjudicating authorities within their respective jurisdictions
Ensure compliance of this.
comply with the above mentioned SOP.
Ensure compliance, because High Court to ensure compliance.
Ensure compliance of the SOP. Then say, it was also pointed out by an Attorney General that
As far as those items in page 2, those future action, that will form part of ongoing deliberations.
that the Department of Telecommunication has drafted the telecommunications in bracket user identification bracket close rules 2025 as well as the draft telecommunications in bracket radio equipment possession authorization bracket rules. The comments from stakeholders, general public have been invited. These rules are being formulated to prevent biometric E-KYC And the issuance of number of SIM cards in one box, besides to route international calls as local ones via voice over internet protocol, etc. So these rules can be notified immediately.
They are asking for 2 weeks.
Or 2 weeks. Let these rules be notified within 2 weeks.
I think a little more time is to finalize.
Don't ask
the
for
rules.
2 weeks.
I know, I told the committee,
All right,
I would like to probably look.
All at 3 weeks. 3 weeks. DOT has also implemented centralized international outroamer in CIOR in October 2024 for addressing the issue of spoof international calls to prevent, which helps identifying calls made by genuine international roaming subscribers.
The spoofed international which helps identifying.
I know.
Helps identify calls for genuine. Probably both.
Compliment होता है.
उसमें आता ना कि spam.
Spam.
वो उसका है. The Ministry of Electronic and Information Technology.
Only one copy given. I see. I think there was a small, the copy which I hand over, it was probably meant for my reading. It's gone to your lordship's hand. I think it makes a lot of sense that way.
But it is helpful.
All in the brackets are all meant to instruct me.
Oh, okay. We don't mention this preventive or anything. We will simply set the rules only. But it helps in issuing the time direction. The
Hotel setup करने के लिए.
G के बाद
Change.
G is already. हाँ. 424 में हो चुका है.
हाँ, नहीं.
Can I hand over another copy?
I would like to get the one with the notes in.
Next paragraph. Ministry of Electronics and Information Technology is directed to develop and finalize a portal for reporting the complaints under Section 43 of the Information Technology Act 2000. That will be done within how much time?
It will also require some time. That will require some time, your lordship. It will also require 4 weeks. Let's be around the same time, 4 weeks. And if we're able to expedite it, I'll come back and report.
Let the need to be done within 4 weeks.
Yes.
Let the need 4 weeks.
उसके बाद ठीक है, सब ठीक.
Rest is fine. That's that. So far as the future course of action is concerned, it is pointed out that I will direct the CBI to expedite a registration of the identified digital arrest cases for investigation. RBI is directed to examine the recommendations of the delayed transactions at the end of the issuer bank and take an appropriate policy decision in this regard. The Ministry of Electronics and Information Technology is directed to follow up with intermediaries for time-bound compliance, for which necessary meetings with the concerned agencies may be held. We don't mention any particular thing. Similarly, we direct the RBI, MHA and Department of Revenue to examine the possibility of to consider the desirability of suspending the suspicion transactions and debit fees under section 12 capital A capital A of the PMLA. Such a recourse, however, will be adopted by following the prescribed procedure in accordance with law. The above, the RBI, DOT, and Ministry of Electronics and so and so, along with Department of Legal Affairs and Ministry of Consumer Affairs, may also jointly hold a meeting to evolve some framework for victim compensation in digital arrest cases. It will be appreciated if a pragmatic approach is adopted and a pragmatic and liberal approach is adopted in this regard. Let a fresh status report, next paragraph, let a fresh status report in respect to the above directions be furnished. Post the matter after 4 weeks on solicitor.
Look, there are a few clarifications. Firstly, in the future actions, DOT is not being covered. In the future actions,
Take the mic.
my apologies. Look, then DOT, in the future action, DOT's pending actions have not been covered, my lords. Firstly, they were to create a dashboard which will include the ISP, TSPs as well as POS, so that the issuance of SIM cards cannot be subjected to fraudulent or additional issuance beyond the caps that DOT itself had mandated. That aspect is not covered in the note at all.
I think
Further,
there are two sets of rules. One rule is meant for this one.
no, not for the dashboard, my lords. The two sets of rules will be external facing. This has to be internal facing, because this will have to be a functionality that DOT, TSPs and POS will have to do together, which has nothing to do with the user framework. The two rules are pertaining to user framework.
Tell them to examine this aspect.
My lords, the second thing,
The status report refers to it at page 3 bottom. We'll examine that.
my lords, the next thing is DOT has the mechanism to impose penalties. That we have raised the suggestion that should also then include compensation. Penalties has to be commensurate with the loss caused due to the negligence or willful misconduct of a TSP or a POS, and that has to accrue to the benefit of victims. That again is not addressed. The similar thing with respect to RBI, this Honorable Court has noted repeatedly the way the systemic rot or misapplication has happened. But RBI, whilst imposing penalties, imposes nominal penalties against banks which are violating its own circulars, which is not commensurate with the loss that accrues because of the violation. For instance, my lords, I have recorded that Mule Hunter as AI tool has been implemented by 86 banks. Mule Hunter is developed by RBI. RBI's own circular mandates that banks have to evolve AI tools, which goes beyond Mule Hunters. Yes.
Kindly turn to page 30 of
The mandate was not just to implement RBI's Mule Hunter, but to develop AI tools which will include velocity checks. And that is what I had submitted earlier also, my lords, that where a digital arrest victim transfers funds which are unnaturally high, even that can be detected using AI tools and can be paused, or it can be a trigger which will then ensure either pausing of the transactions at the issuer bank itself or at the receiving bank's end. That itself becomes a trigger. That has not been addressed.
Give a note to the
My lords, this has been raised at the committee meetings, and they will have to revert on that. But since my lords are saying that the status report will have to include this may also be added, my lords.
Just give a note that during.
Lords, kindly turn to page 10 of this status report, Annexure R1, action taken by RBI. At the bottom of that page, the following discussions were held and so, and cyber-enabled frauds. RBI informed that 26 out of 53 major banks have adopted the Mule Hunter AI.
Yes, that is my submission. We are not just talking about detecting mule accounts.
1 minute.
It goes
and
beyond
that.
that.
And clarify that Mule Hunter AI is supplementary and not mandatory. The Honorable Supreme Court directed use of AI ML tool generally and not any specific solutions. Many banks have their own AI ML tools for fraud risk management. The detection efficacy of Mule Hunter AI varies across banks from approximately 25% to 90%, and concerns are noted regarding high exposure bank. It was noted that RBI and 14C I4C MHA are examining a draft MOU for sharing suspect register data to enrich mule account detection tools. So I think,
my lords, this is that all of this pertains to mule accounts, not to velocity checks.
One thing is there are in situ circulars with regard to reporting compliances.
Yes.
no.
That if RBI can strengthen the compliance of the reporting duties of the bank.
Certainly, therefore the
with regard to suspicious transactions and suspicious accounts.
And my lords, if the
Perhaps help
RBI
at an
ombudsman,
early detection and thereby some remedial.
my lords, in every case of digital arrest, the submissions that have come point out that the RBI ombudsman has not really taken into account the kind of situation in which the scam has happened. They merely say you have voluntarily transferred, and that was the first submission that RBI made at the committee also. So the fact that the victim transfers voluntarily is part of the scam, but that cannot be held against them for compensation or for remedial action.
I would suggest all these concerns.
The requirement of banks to develop AI tools and implement them goes beyond finding mule accounts. That is my submission, my lords, and that is RBI's own circular, which forms part of my first submission.
That matter may be better left up to the central bank.
My lords, and therefore,
left to the central bank.
my lords, my submission is that RBI should
Better tools.
implement
They
it,
are showing.
enforce penalties if there is a violation. Merely having a circular will not ensure implementation unless there is a penalty that.
We are in the process of consolidating it, so do you have a complete clarity on how it really works? So certainly RBI is going to look into it. And
See, there will be certain gray areas where probably with a view to whatever maybe, we will not say that it is their compulsion, but they will not like to pressurize the banks to adopt certain things. They may not like to pressurize. But that does not mean that we will also finally agree to that. We will see that what is to be left for to be done by us.
My earnest request.
if only RBI detects that there is a complete, yes.
If RBI does not take any stern policy decision even at this stage,
Yes.
when the the information in public domain, official or unofficial, suggests that definitely more than 25,000 crores rupees.
Yes, I
This
know.
country has been refunded. The one of me, it talks of 54,000 crores plus. 54,000 plus crore of hard-earned money of these victims has been siphoned, taken away. That's why I was telling before lunch in some other matter that it is not extortion.
I heard that.
Brazen loot.
I heard that, yes.
And this is absolutely robbery and dacoity. Now, if the banks, if it happens either because of the collusion of the bank officials or if it happens because of their negligence or their perceived action of not annoying the customer. So that means that a kind of a tacit appeasement of the customer. It is not. The banks also need to realize that a customer, if suppose there is an account of a corporate entity, every day the transaction of lakhs of crores is taking place. There is nothing like doubtful in that transaction. But a retiree who is only withdrawing rupees 10,000, 15,000 per month and suddenly from his account 50 lakh, 70 lakh, 1 crore is being released. Why your AI operated, there's some app in the bank will not peep alarmingly that this
That's why
transaction need
this
to be
note says-
rechecked.
I understand that. That's why this note says on average, but about 75% is successful. So where it has not been able to work for a variety of these reasons, I think RBI will address that question.
Because we hope that they don't invite a direction, and if the RBI can introduce some.
No, morning I had
It
discussions
has to
with
be a very
High Court.
robust mechanism. This definition of suspicious transaction is the central point for consideration by the banks, whether they are private financial institutions or public sector.
Have the circulars as to what is the suspicion.
Yes.
It's a huge network that has developed over a period of time.
Mr. Attorney,
So on the
this-
mule account that are
problem is the banks are more into a business mode, and naturally so, with ideas of profit earned. And in doing that, what they are becoming, either innocently or maybe connivingly, the platforms through which there is a very swift and seamless transmission of the stolen proceeds of crime. You see, your report says 52,969 crore to be misappropriated from April 2021 to November 25.
But you will not see the drop in now after
This is more
the
than-
past 6 months.
This is more than the budget of several
I'm
several
talking
states.
in terms of the ability of the various banks. I've seen the curves. So it varies from bank to bank. In some banks it is completely, it has dropped down considerably.
But
Yes.
Mr. Attorney, that is where the central bank
Exactly.
is the
Exactly.
nerve center. It needs to give points to the banks which have better reporting compliance. We cannot predict policy, but it's
Certainly.
for them to formulate
Certainly not.
safe policies.
In their over anxiety of making business, they must understand they are trustee of this money. The people have deposited it only because they have trust in them. And if that trust is defied,
I saw some information in the morning between private banks and PSU banks. Some private banks also have been failing regarding their commercial, concern. So it all depends on what instrument, or probably universal.
Their annual reports show only profit leverage. They do not show compliance leverage.
Some PSU banks score high
Being
on.
compliant is not shown.
what is happening is that these banks are, in due course of time, they are becoming a huge liability on the public at large. The courts have become their recovery agents. They lead into granting recklessly loan amount to these fraudsters.
That's a story.
All the so-called.
That's a different story.
And then you have NCLT and a battery of quasi-judicial system only to recover money for them. Why?
Yeah.
They should be punished. They should be in
That's
fact put behind the bar if they are indulging in this kind of thing. Their managements.
That story will certainly take into account.
Now they don't care to even check these transactions. People are high and dry.
I'm sure with the RBI getting into the matter and then developing.
This is the professionalism or quality of banking which they are showing inherently wrong with their way of functioning.
Lord, and where the RBI itself has shown some of the banks to be negligent. The RBI ombudsman should necessarily then consider a victim's petition in light of that negligence on where should the liability lie. But that is not being done, my lords. Today, the victims are not too clear about where their remedies lie. Therefore, if there is a direction to the RBI ombudsman to entertain.
Why, Madam RBI ombudsman, whenever this suspicious transaction take place, see, our country, we are so advanced in technology.
Yes.
First of all, you have to have only AI based. They don't require extra staff for it. What they require is only an app, which will detect that this is the trend of the transactions in a particular account. You are not closing that account. You are only stopping it, only for re-verification.
That's right.
Immediately from the bank, a message should go to that here is alarming message. And simultaneously, most important thing is that message must go to the nearest cybercrime police station.
That's happening. All that SOP takes care of all of that. SOP takes care of each one of these minor details. kindly turn to page 52 of the report.
Any suspicious transaction
Yes.
must be reported to the cyber crime police station.
This SOP will address all of them. That's why I said once the SOP is put in position, you'll see
Well, it
the.
will take up after 4 weeks.
I have
Meanwhile, you study all these assets.
I'll also have a review. Milords, there are two corrections. At H, the Ministry of Electronics, MATI, has said that there are complaints under 43. It's not clear why they want to invoke 43. Firstly, 43 is civil penalties. It will have to be 43 read with 66 IT Act. But that goes into hacking, virus attacks. It would just create confusion in the minds of victims. The request or the suggestion was for either a separate portal for digital arrest victims or for financial frauds with clear headings for digital arrest and various other forms of financial frauds, or in the main NCRP portal itself to have a separate vertical for financial frauds and for digital arrest. 43 seems a little bit of a miscalculation there or misapplication.
No, this is work, it is in progress.
That goes into issues of hacking, virus attacks, distribution, denial of service attacks.
You see, that portal also, to my mind, once you create a portal, then they will shift onus to all the victims.
That's
that
right.
you have
But
not reported.
NCRP is already there in that sense then. So why another portal which goes into all the other kinds of cyber crimes?
No,
What if we read with
let's
relate to others?
make some progress and find out where it doesn't work.
All I'm saying is this may be modified to say, let there be a separate.
Let us not do it today.
Either financial frauds or digital.
Give a set of suggestions to him.
Milords. And one final correction, Milords, at 2E, Milords had noted about the examination possibility of suspension under 12 AA PMLA. It may also add 106 BNSS, Milords, equivalent of 102, because PMLA may not be applicable
It's covered in the
to
SOP.
cases.
Covered in
There
the.
in the SOP.
Milords,
Yeah, there.
since there is a direction from Milords on PMLA,
You
that's
are saying
why
We have directed
the other side has also started coming before us. We are
that balance is what we are trying to.
We had Article 32 saying that this.
Milords, that balance is what we are hoping the SOP will bring in.
Francis,
consciously
PNS is
mentioned.
being applied indiscriminately and freezing of accounts taking place throughout the country.
Milords. But in a way, 106 BNSS and 12A PMLA capture what the Scams Act of Singapore effectively provides for, Milords. So one issue that arose was, do we need an equivalent law of Scams Act? We don't need that. Existing provisions can be applied in similar vein.
That can be crossed later on, but
Yes.
the existing provisions be really given effect.
So let us see that what comes out and then what is left out, then we'll see. We'll examine that part also. We post this matter of give a date on.
And may I request for an NMD date, my lord, since the matter will be heard at
The
length.
turn may or may not come. That's why we are
My lord.
purposely keeping on Monday.
My lord,
Even not on Friday also.
my lords.
The things on Monday. On a Monday after 4 weeks. Immediately after 4 weeks, whichever the earliest Monday, fix it on that date.
May well have your lordships leave.
Don't file individual matters. You tell the learned bikers or to the learned attorneys, we'll see what is to be done.
May your lordship leave also to make a request. Item 36. There's an IA regarding the CAT Bar Association. The Calcutta High Court has virtually said the functioning of the tribunal. Item 36.
Items?
And one's case.
There are two interlocutory applications there. One is IA number 42091. That is for implement in the main CAT Bar Association. Then IA number 42093, where we seek a stay of the High Court's direction. The High Court says the tribunal will not function. And then, in fact, in another matter from Kerala High Court, somebody filed a co-warrant petition saying members are appointed in terms of the Tribunal Reforms Act will not continue to function. So I'd probably give a lordship that writ petition number also. I think both these matters should be transferred here. The lordship should hear these matters.
No, we will hear that, but why benches are not constituted on it anyway?
Today was the day the tribunals are not functioning.
Yes.
Court said you will not function. Kindly see the interim order passed by the High Court. 4th of 29, they issued notice, and 4th,
So what is the order passed?
there's an order dated 4th of January, 4th of February.
Where is that order?
Can I hand over a copy of that?
Lord, kindly come to page number 163 of my IA application. IA number 42095 of 2026. The High Court directed tribunal should not be functioning. Madam.
36.
36.
At page 2 of this order,
Just a minute.
paragraph number 2.
Why the CAT bench is not holding
Page-
court in Port Blair?
Kindly turn to page 2 of this order.
The impugned order is page 160.
Paragraph 2 at page 2. Therefore, pending disposal, we direct circuit bench will not function.
Wait the order, कहाँ तक clear the files?
We handed over a copy of the 4th of February.
IA number 42095.
Kindly, 4th February order, page 2, para 2. The High Court proceeds on the footing merely because the tribal reforms had been struck down. Members appointed to various tribunals will also cease to hold office.
Which paragraph?
Paragraph 2 at page 2. Pending disposal so and so will not function.
We direct the
That cannot follow.
On the top, it is decided that the circuit bench is known as in the eyes of law. Since
The High Court-
in terms of
The High Court proceeds on the premise
have been struck down by the Honorable Supreme Court. The time, energy, and money spent in proceeding with the matters would stand wasted. Therefore, pending disposal of this issue in the present proceeding, we direct that the circuit bench of Central Administrative Court Blair will not function.
no, this is absolutely against
the High
the
Court may just explain.
Constitution Amendment of 323A and B of the Constitution of India. And our larger bench reason also there in terms of the L. Chandra Kumar judgment reported in 1997, 2 SCC page 261. The L. Chandra Kumar said all
So
the
the effect of, if at all, the effect of the judgment of this court is
Yes,
that instead of 4 years, their tenure will be 5 years.
that's right.
Yes.
Therefore, the question.
Assuming.
You're right.
So that means that they will rather continue. If there is any
Continue,
question,
yes.
discontinue.
Can you clarify this in a stay of this order?
Exactly, that's the most pragmatic way of looking at it.
Say, having been brought to our notice,
Yes.
the matter by learned counsel for the petitioner bar association, as well as by learned attorney general for India, we stay operation of the order dated February 4, 2026, passed by Division Bench of the High Court at Calcutta, in bracket circuit bench at Port Blair, in MAT/5/2026, area number 7, serial in order set. Consequently, we direct the chairman of the Central Administrative Tribunal
Yes.
to depute the circuit bench
Yes, madam.
at Port Blair
We're supposed to commence today because of the stay order.
forthwith to enable that circuit bench to hear the matters
Yes.
on day-to-day basis.
Would it be in order for to transfer these petitions here so that I find, as I said, Kerala High Court is entertaining
Yes.
certain petitions. Therefore, we're going to have problems all over.
Since the matters reforms of different tribunals is pending consideration before this court, we deem it appropriate to transfer MAT 255
in Madras Bar Association says the appointments prior to 2021 will continue. The appointments will not.
But the rules of formal appointment, but in this regard, we have used para 155 of the recent judgment of this court in so and so, so and so. So, having regard thereto, we deem it appropriate to stay operation of the order dated 4th February 2026, passed by the so and so, so and so. Was pehle likha tha. Next paragraph. We also deem it appropriate, since the matter of the reforms in tribunals is pending consideration before this court. M80/5/2026 pending before the High Court at Calcutta.
Circuit bench at Port Blair,
This is before the circuit bench only.
which is pending before the circuit bench at Port Blair. Calcutta High Court, circuit bench at Port Blair.
Before circuit bench at Port Blair. As also which is the matter in Kerala.
There's a writ petition number 46504 of 2025. I'll give the list.
Are ordered to be transferred to this court. Transferred to this court.
But till such time, I also pray before your lordships.
We request the other high courts, we request all the high courts not to entertain petitions with respect to the constitution, continuation or composition of the tribunals of the national state tribunals, to the extent the issues are pending consideration before.
But I also pray one submission before your lordship, the High Court overlapping the jurisdiction of the tribunal entertaining.
We have stayed the.
Grateful, Malad.
Don't want to.
But both I application may be allowed, Malad. Yes. I also find out.
Service matter that the High Court is justified in entertaining writ petition. The only thing is that issues are pending before us. Therefore, we don't want any parallel.
Yes, yes, Malad.
It is not that the High Court is without jurisdiction.
Can you fix a specific date, Malad? Any date, lordship, can you fix, Malad?
What is left, otherwise we have transferred the case better and we set aside the order dated.
That's right.
We set aside the order dated 4th.
That's right.
Matter and.
Yes, yes.
So then list on so and so date after transfer, after 8 weeks.
Grateful, Malad.
All right, thank you. Enough.
Grateful, Malad.
Yes, next item. Now, so pure matter, Mr. Diwan.
Yes, grateful.
Person present before, so she is going to be not makes that the submission back that's up your change.
She can't hear, sir. Just a minute, wait for the turn, please. Which item are you referring to? Which item number?
I was in 40.2 where I had handed over.
My friend is talking about 40. Mr. Diwan is 40.2. I'm 40.1. I think Mr. Diwan was on his legs last time. I thought Mr. Diwan could start.
Just a moment.
Before that, this is the sufferings, the harassment on the ground of non-citizen. How accepting such objections?
Your assistant, Mr. Diwan? You're with him?
You complete that. Someone objected to that mind.
We have already pointed out last time, even without arguments, we have told them to rectify it.
500 people.
So get Wait for a minute. Then let us advert to the last order what we passed and let us see what is the compliance.
Because the last order is on 4th of February 26.
4th February, that's it.
Your Lordship was pleased to issue notice in certain writ petitions. And thereafter,
Para 5, I think, Mr. Diwan.
Yeah.
Para 5.
yes, para 4 and 5. Yes.
Oh, para 5 is only for listing the other matter, then where the main order.
No,
There's the 3 petitions which are captioned, where your Lordship was hearing us,
January.
just above para 4.
January.
There were these directions, there were certain observations your Lordships had also made. So if I may be permitted, just continue with that note. I'll bring your Lordships up to date with the further developments that have occurred over the weekend. And we'll just make our short submissions.
That no application for judicial is being taken, I can discuss on identity and address. And the Crown cannot prosecute.
Sir, if all of you will start arguing together, then we will not be able to hear. One by one, we will hear all the matters. Yes, Mr. Diwan.
Yes. Now, Manoj, may I just request the court to take up.
Before Mr. Divan, sir, it just being consecutive. 14.6 is the repeat. An organization called Sanadani Sanchit filed an IAML, including certain, praying for certain beliefs, which I think respectfully deserves your Lordship's attention. Let
My
Mr.
lords,
Divan go on.
my lords, this petition, I appear for the state.
Yes.
This is supposed to be a public interest petition.
correct.
This is an organization that takes care of temples. What interest they would have in overseeing an election is a moot point. But that's the first point. That's the first point.
Persons who go to
and the
temples
second
also
point-
go to polling booths. to
Yes,
vote.
of course.
Yes.
Why
My lords, and
aversion
second
for
point,
temple?
may I just say
Why
this?
this aversion for temple?
No, may I just also,
That's not the right way.
may I also just say this, my lords? Your
But,
lordship,
sir, the-
your lordship's
Let-
last order.
Problem is that in none of the matters we are permitting petitioner side to argue. It is happening there with Mr. Diwan also, it's happening with Mr. Giri also. Let us hear one by one.
yes,
We are,
that's
One thing, my lord.
I'm grateful.
we are not shortage of time. We will hear. Mr. Giri, what is your matter?
Item number 40 was our matter, my lord. Well, item number 40. There are certain problems which are happening every day, my lord. We are trying to draw your lordship's attention.
See, if you people will not maintain discipline, then you must know the nature of your Chief Justice. I will throw out all the matters, will adjourn the cases and will stop the hearing. If this is the way of you people.
Where will you go, my lord?
We are hearing concepts, we are starting the argument, somebody starting speaking like this. Is it the way to argue in court? Are you sitting in a grain market or you are in court number 1?
I just request the court master to hand over that note. We have given it last time as well. Justice Acharya, we have given extra copies also today.
Where is that note?
Yes, it was given last time, but we've given furnished an extra set as well. This was the note which was circulated on the 4th of February. I think I'll just mention 2-3 things and then rapidly try and just make my points. You may have a marked copy from the previous occasion. You may. But in any case, this one is a fresh. So, Manoj, may I just, your Lordship has that cover sheet? Correct. So this, Manoj, I just want to apprise Justice Sanjaria on 2-3 points.
Yes.
We had, yes.
My brothers are not here.
Just very, very quickly, there's a, as your Lordships know, there's a special intensive revision of the electoral rolls as far as West Bengal is concerned. This case essentially deals with that. There is a time that process will end on the 14th of February. So there is tremendous urgency, my lords, with respect to the specific directions which we seek. There are 4 or 5 heads under which we will be making our submissions and suggestions. On the last occasion, on 4th of February, there were certain observations which were made by the bench, and we therefore, pursuant to that, have handed over. I'll bring your Lordships up to date on that. That's the general conspectus. There's just 2-3 figures I want to give your Lordship. The first is, sorry. Yes. The first figure, which is actually not in my note, and which you may just note, is that the draft list, the draft electoral roll, which was published, has approximately 7.08 crore electors on it, the draft list. Please note that figure. The second figure is that out of these 6.75, I'm sorry,
Approximately 7.
approximately 7.08 is the draft list which was published around the 16th, I think, of December 2025. Out of these 6.75 crores, approximately 6.75 crores are mapped. By mapped, what it means is that each of these electors was mentioned in the 2002 list, so they are mapped, or they were identifiable through some family member, etc., some relation in the 2002 list. So 6.75 are mapped. Now, we are really focusing on this particular 6.75, sorry, and just to indicate, 32 lakhs were therefore unmapped. 32 lakhs were unmapped. I am primarily focusing on the mapped, and my first submission, which we had made last time, was that 1.36 crore of the West Bengal electors were found through a process which was known as logical discrepancy. Your Lordship will recall that. So that was a computer program which they ran.
Where is that order where we dealt with briefly about this mapped, unmapped and logical discrepancy?
Yes, Your Lordships have dealt with it on the 19th January order.
19th January.
If Your Lordship has 26838 IA.
IA 26838.
Which page was it?
IA 26838.
Which page was it?
Page 30. 40 points.
Your Lordship has it, page 38.
19th January, para 2 of the order.
Yes, may I just place it? It appears that approximately 1.4 crore individuals have been issued notices for the purpose of document verification. These notices are broadly categorized into 3 parts, mapped. That is the category of voters who are linked with the 2002 SIR. 2, unmapped, the category of voters who are not linked with the 2002 SIR. And 3, the third category involves logical discrepancy accounting for approximately 1.36 crore voters. Now, just a pausing here. These are all mapped. 1.36 crores are all mapped. The documents brought on record by the parties indicate that within the category of logical discrepancies include, inter alia, a mismatch of the father's name, a mismatch of the parent's age, a difference in the parent's age of more than 50 years, a difference in the grandparent's age of less than 40 years, and those having more than 6 progeny. With view to enabling the persons who are, as of now, included in the category of logical discrepancies, we deem it appropriate to issue the following directions. The names of the persons figuring in the logical discrepancies may be displayed in the Gram Panchayat Bhavans, public places in every taluk, and block office in every taluk subdivision, as well as in the ward offices. 2, persons likely to be affected are permitted to submit their documents and objections through their authorized representative. Such an authorized representative can even be a booth-level agent. There shall be an authority letter in favor of such representative, whether signed or thumb mark, and documents and objections may be permitted to be submitted by the Panchayat Bhavans or block offices. The Election Commission of India shall issue instructions for providing an additional 10 days' time from the time of displaying the list in the Panchayat Bhavans and block offices to all persons who have not yet submitted their claims, documents or objections to do so within the extended period. The state government shall provide adequate manpower for Election Commission and the state elections for deployment of Panchayat Bhavans block offices to handle documents, objections and hear persons likely to be affected. In this regard, we direct the District Collector to meticulously follow the instructions issued by the Election Commission of India or state government for deploying adequate staff and forces to ensure smooth functioning. The Director General of Police, West Bengal, Superintendent of Police, Collector are instructed to ensure that there are no law and order problems at the location and that the entire activity proceeds smoothly. All affected persons may, in addition to being given an opportunity to submit documents, materials or objections, also be heard at the time, either in person or through the authorized representative accompanying them for the purpose of making an appropriate decision, and the official will also receive the documents at the hearing, may also certify the receipt of the documents and the conduct of such a hearing. This para 10 is important. The Madhyamik class 10 admit card, which discloses date of birth of the candidate, may be submitted as part of the Madhyamik pass certificate during the hearing. Your Lordship.
My brother will now.
Yes, now Your Lordship, I'm very obliged. Yes, absolutely right. So, my Lord, this was the background. Now, my Lord, I'll just go to my point by point. Now, if Your Lordship just takes up my note, please just go straight away, if Your Lordships would, to page 4 of the note.
Page 4?
Yes. Your Lordship has, sorry?
Yes. Submission
Yes.
para 7.
Yes, paragraph 7, right? So now this was the first set of points. A majority of the logical discrepancies, more than 50% of 70 lakh, are cases of minor name mismatches or spelling variations. For example, Roy and Ray, Ganguly and Ganguly, Datta and Datta. A sample set of discrepancies is enclosed at page 8. Now this, my lords, we had projected on the last occasion. Your lordship may just go to page 8 of the note. Yeah, 50%, my lords.
So if you read your para 7A,
Yes, 7A.
conjunction with para 2 Roman 3,
Yes,
our order of 19 January,
yes,
that means out of approximate 1.36 crores,
yes.
70 lakh people are those where this mismatch or some
On names.
typographical.
And these are mapped individuals. My lords,
So
please.
last time, if
Yes.
you recollect, last
Yes.
time we said that
Yes,
because of the known availability of sufficient manpower,
yes,
the election commission was compelled to take up persons from the outside the state.
yes, special
That
officers,
micro
yes, yes,
something,
yes.
observer,
Micro observers,
whatever
yes,
it is.
yes,
But during the course of hearing last time,
yes.
verbally.
We indicated that we would.
Yes.
We have given them the particulars of 8,505 officers. We've arranged it, and I'll just hand over. So just give the note.
Because
Just
what
the
will
note.
happen is
Sorry.
that suppose a person from Delhi
Yes.
or Rajasthan or Punjab origin, suppose he goes there,
Yeah.
he will not be able to understand this mismatching.
Yes, so
issue.
that's one thing. And the second element is, of course, also, my lords, on respect of jurisdiction, which we'll come to. But if your lordship just takes up this supplementary note, which I've just handed, just to respond to the, yeah, just give this. This is exactly to answer your question. Give it to the other side. Give it to the other side. Page 6, my lords, page 6. Please go to, yeah, this is the email of 7th of February, which was on Saturday. In terms of the observations made by the Honorable Court during the hearing of the captioned matter on 4th of February 2026 and under instructions of the government of the state of West Bengal, please note that West Bengal is ready and willing to make available 8,505 number of Group B officers.
This mail is being sent on 7th February.
Yes, it was on the weekend, my lords. It was on the weekend, but we had to get the available officers. All the particulars are given. Because we have not burdened the record here with the individual names, but they have been supplied with the individual names.
Have you sent the list of these 8,000 something?
Yes, yes, yes.
Have you received this list?
Yes. So, my lord, your lordship will see the
Kindly see the
district-wise.
next page. In the same note, kindly see the next page.
Yes, the next page.
This is what they say the detail.
District-wise indicative list of number of Group B officers who can be made available, and we've particularized the names. The names are given and were sent.
I'm afraid, my lords, no names were given. This is all that we have received. At 12:30 in the afternoon on Saturday.
See, because how, that is the whole problem.
Yes.
The officers with their full nomenclature, designation and particulars.
Yes.
The names will have to be sent, then only they can take them temporarily on deputation, kind of.
Yes, yes,
That is
yes.
statutory deputation.
That will be furnished. We've given the particulars because we asked them kindly confirm the same at the earliest, whereupon the requisite particulars of these officers shall be shared.
Only number is given, not the names.
No, the names are fully compiled. If your lordship sees the email at page 6 of this note. Kindly confirm the same at the earliest. So we furnished the district-wise particulars and we said that you please just confirm whereupon the requisite particulars of these officers shall be shared. For further action, so they can be immediately deployed, my lords. These are all made available. Yeah, you give it to them.
Never made available, my lords. They want it.
Sorry.
See, we don't want any dispute on facts.
Yeah.
Because then we will have to ask the chief secretary to file an affidavit that has he sent the names to the, because commission says.
No, my lords, I am told that we were awaiting the confirmation. The names are compiled and they are ready, district-wise and designation-wise, as your lordship indicated.
Group B, all Group B.
They are all Group B.
Till 12.
Yeah.
The mail is being sent around 12 o'clock.
Yes.
The names are not.
The advocates to the advocates.
And for the government, the lordship wants the numbers which I can offer for this. Micro observers.
No, but
What the numbers?
Singhvi,
It's not micro observers. Dr. Singhvi, it's not micro observers.
you know,
No,
state government officers who are supposed to be sent.
Yes, so therefore, one is Group B officers.
And ideally, on 4th February, when a statement is made before us.
Yes.
On 4th itself or on 5th itself, they could be sent the names so that these are the officers.
There's some confusion. No.
Because we took a little time to compile the names. The state took a little time. By the time that then these advocates sent it across.
But even till today, the list has not been sent. Names
The
also
list is
sent.
available, my lord.
We send them from AR to AR to
It available.
confirm. Just note two things, Balus.
Mr. Diwan, there is a
Yes.
difference. If you will see the scheme,
Yes.
it's not the names available. It's the question the officer will have to go and report to the district electoral officer or the state election commission.
Because the request was that the request was that you please confirm to us and we will immediately provide the particulars because the only.
We were not required their confirmation because this was the statement made before us during the course of hearing.
Yes.
So you were only supposed to comply with what you said before us, sending the names of 8,000 plus whatever officers you want to send.
Yes.
That here are the officers in terms of the observation.
All right, so we'll
As
furnish
rightly
that.
mentioned in the
Yeah, we'll immediately furnish the list. There's no problem.
2 minutes. Number one, this is the entire list. I don't want to load this here for the court. This is the list. But
Dr. Singh, the lists were not supposed to be sent through the court.
no, Malas, it's not. It was Malas, that explanation I'll give. But just see the note of 2 pages for a minute. Malas, they are saying that they didn't know about it. Just give that note. Please give it for madam. Please give this note first. Madam, this note. I'll just take 2 minutes, Malas. Because impression is given that we were not ready with the names. My lord wants Malas Gazette Class B because the earlier
It has to be because unless you will give the details of the officer.
Correct. Now, just give me 2 minutes on this, please. Just come to para 5 of this note. I'll just take a few minutes on this note and then I'll tell lordships.
Yes.
Till 4th of February, I have deployed rather, 80,681 BLO appointed by the ERs in terms of ECI notification, the rejoinder, etc. Forget it, I've given the actual pages, where BLOs would be appointed at the first instance among any Group C and above regular serving employees of the state government enrolled as an elector. 8,524 ARROs appointed by the ECI with a notification dated 29th, 26th, 18th, etc. Dates are given. Being employees of the state government. These AREs are majority from Group B, rest are from A and C. They are typically, this is important because what Lordship got earlier were craftsmen and teachers and well as painters. PDO, Deputy Secretary, BDMO, Inspector, ICDS, Revenue Inspector, BLRO. 294 EROs appointed being Group A employees of the state government. They are officers holding respective offices in terms of ECI notification, being officers who have completed 9 years of continuous service, equivalent to SDM, SDO, etc., etc. rank. ECI has wrongly contended because West Bengal did not provide SDA rank officers, it was compelled to appoint 8,000 micro observers. When these MOs, these officials are of much lower rank, including art and craft, teachers, master craftsmen, customer, no idea of local culture, no idea of local management. ECI has objection to appointment of non-SDO, SDM levels as ERs. They are the letters of ECI. By letter dated 17th of October, I clarified to the ECI that officers of only the ECI notified designations have been provided, which are approved designations by ECI in previous elections, and no new designations not used earlier was considered for appointment of EROs. 294 represent all the 294 assembly constituencies.
Yes.
Then Malas, just turn the page. Certainly Malas para 6, your lordship will just note, all these offered as so-called micro employees or micro observers are Malas of very remarkable categories and from PSUs and central government employees having no connection with the local culture of West Bengal. None. I have highlighted 3 quaint ones, Malas, master craftsman, art and teacher, customer assistant. But even the others are Malas of PSUs. They are not local. They are only central government PSUs and central government departments.
So what is wrong with that even if the central PSU? The question is very simple. Micro observers are from outside. So whether they are PSU or
I'll
the
tell
central
you,
employees.
then let me answer that. My lord is right. They are, look at the level, Malas. They are clerks. They are customer assistant. They are master craftsmen. Malas, the person has to do the job of a BLO. My lord will see what the one size fit all will not work here, Malas. These are not people who are in any manner versed. Look at my categories, Malas. The people I am giving, BDO, Deputy Secretary, BDMO, Inspector. That is the point being made. A, rank-wise very low. B, Malas, training-wise inappropriate. And then Malas, last 2 paras, 7 and 8, approximately 1 micro observer per arrow has been appointed. Such micro have been appointed from central PSUs and other organizations. They have no connect with Malas West Bengal. They've not served there. They don't know how to handle it, Malas, straight away. If you put a clerk there, Malas, then in any event, the state I was reading, that was para 8. In any event, I am now making, I am meaning the state government, Malas, available equivalent number of such further Group B officers across the state. Approximately, I am told it is 8,100, subject to correction. 8,500 or 500. Equivalent number. An indicative district-wise list, etc. Now, Malas, I understand that these were sent through advocates on record.
Your para 8, now in your today note prepared, you are saying that now you are making available them. So obviously, now this is being acknowledged also, that nobody has forwarded this list of 8,500.
Apparently, it was forwarded. Yes, very well.
Had it been, say, sent on 5th of February itself, on 4th when we heard the matter, by now they would have taken a decision, we would have called upon them that you please tell us.
See para 9. Well, I can't, suddenly, my learned friends are also making arguments here in court only. The ECI never requested the state, never earlier, to make available further Group B officers. And the question of failure to do so cannot arise. Only the court at the Honorable Court at the last hearing made a suggestion. That's how it can only be between then and now.
Yes.
And they can perform the roles, the roles which are required, which I have itemized at page 4, etc. All I am saying is, this is a correct way of doing it. They have never involved us. They have never asked us. They have never, I suppose I could send it so moto, but that would hardly have any meaning. Your Lordship did observe this orally last time, and we have promptly put it on record. That is as far as the numbers go. I have other things to say on other issue, but this is only on the micro observer's point.
So your Lordships may take it that now that list of 8,500 has been now handed over of individual officers, because
no, it has not been sent. Now probably up till now it was a proposal to send it, but now in any case you can send it. We can ask examine in particular.
We've handed it over just now because we were waiting for their response. But now
nothing has been
formulate this point.
I'm afraid nothing has been handed over to us when it comes to the names. When you're talking about 8,000 and odd names.
It's taking time to reach you.
Yes, I agree.
No, sorry.
They have just given it.
So ask one of your juniors to see that whether the names, designation, place of posting, contact number, anything is given.
We will check them, Melis.
Because these were the basic thing required.
We've also given copies for the court.
This one, yeah, this one.
No, it's kept behind.
Oh, I see. It's kept on the table behind the justice company.
The purpose of notification is
Going to contact them, Mr. Diwan. And or have they been instructed to report to the local district election officer?
As soon as they do it, we can immediately issue instructions. It has to be done because it can't be that people in this number are just excluded even though they are mapped because of some name discrepancy, because that's our essential point.
How many of them?
Certainly it be expedited. And that list is
He gave 8,000.
this one.
8,500. This is 8,500. 8,500. We'll see that one. Now I'm talking about the note.
So can these persons report to the concerned EROs by tomorrow?
Yes, yes, yes. Yes.
So, Mr. Ravi, first of all, because of this, unfortunately, these are again incomplete kind of particulars. We do not know what does mean this SAG2, ACS, head clerk in which office?
This is competition. Assistant competition.
Department is mentioned.
This is broad division clerk.
All right, all right.
This is SAG.
So the department is also mentioned.
Yes, sir. DPO is drawing and dispersing office.
So first of all, your EROs, the designation is ERO, no AERO.
No,
This will be
they are micro observers.
They are
They will
micro.
report to whom? They will report to the ERO.
They have to report to EROs and AEROs.
ARO comes. ARO.
The irony here is that, Millers, before I could get into any other detail, EROs and AEROs are, as they have supplied Group C officers, etc., they are subordinate to these Group B officers who are supposed to be advisors. They can only micro observers. They have an advisory role, nothing else.
These AEROs
Yes.
are all state government officials.
Yes, Millers.
They are state government officials.
Yes.
And their designation is
Lower than, most of them, lower than these micro observers. I'll explain this, Millers. Millers, we wanted,
lower than micro observer, lower than the officials list now being given.
yes, they're all Group B officers. May I just explain this to me, Millers, to your lordships?
AROs are either Group A or Group C officers.
We wanted all Group B officers, 300 of them.
Yes, sir.
They have given us only 80 of them.
Yes,
The remaining, they have given Group C an assortment.
How many? 80 are Group A officers.
Group B, Millers. Group B officers, 80, not the remaining.
800, 8,000
No, they are about 300.
Group B officers.
Yes.
AERO are already appointed.
Millets, when we wanted,
AERO.
yes.
They are only going to assist.
I'll answer. Just Millets, if they are quiet, I'll answer everything so that they could answer me. Rather, whatever the issue that I've raised.
You have one AERO. You have one AERO in every constituency.
Yes, Millets.
No, can I just solve this, fellas? These are all BRO. These are all Group B officers. This list, this big list. They will all report to EROs, all of whom are Group A.
No.
294 constituencies, 294 EROs, all are A. All of these are B.
The very unfortunate thing, Dr. Singh, they are refuting in your presence only that they are not Group A officers.
No.
Millets, out of 300, out
They are
of
B, they will report to A.
out of
They are
300,
no, no.
let me complete, Millets.
Is there any officer of the state of West Bengal to whom we can catch hold? The problem is that somebody is irresponsible.
Of course, fellas, he has to be here.
What is his designation? Please come bring him in front.
Of course, he is.
So, Mr. Chief Secretary, you are here.
Former Chief Secretary. He is now the Principal Secretary to the Chief Minister. He was the former Chief Secretary. So he is.
All these 294 are Group A only.
I am afraid
Group A.
is
All the
completely
294 are Group A only. And all the 294 constituencies are Group A only at the ERO level.
The problem is that we are basically, when we are stuck, we are stuck. We will not proceed further. Now, the gentleman has been Chief Secretary. Now he's advisor to the Chief Minister. So who knows better than him, after all holding the executive head of this the state civil services. Now, can you, what's your good name, please?
Sir, Manoj Pant.
Mr. Pant, can you please tell us that 300 names which were required to be sent for the purpose of AERO? How many of them are Group B? How many of them are Group A? Or how many of them are Group C employees?
Sir, all EROs, 294, they are all Group A officers. Either of the rank, all are of the rank of SDO or SDM. They have completed 9 years or more service in the West Bengal Civil Services. And some of them are IAS officers as well.
EROs?
EROs.
Or AERO?
EROs. Electoral Registration Officers.
Now,
294.
in every constituency, there is one ERO.
Yes, every
Right?
constituency.
And how many AEROs?
8,524 AEROs are there.
Approximately in one constituency of assembly constituency, how many AEROs are required or normally deployed?
3 to 4.
3 to 4.
Sir.
So, say approximately in your state, you require how many assembly seats are there?
294.
294. So let us take it 300.
Sir.
300 multiplied by 4.
300 multiplied by 3, around 3, sir. 900.
All at 3. Then you require 900%. 900 AEROs. How many names you have given in the AEROs?
8,524, sir.
Now you are giving.
No, this is previous. These are AEROs, sir, who are already appointed, who are working under EROs.
What is their rank and designation approximately?
Of the ranks of Group B officers, 65%, and yes, sir, and Group, otherwise all are Group A and Group C officers.
All are Group
Group A and Group C.
No, 65% is.
65% are Group B.
How many are Group C out of them?
10% to 12%.
Only 10 to 12% would be, sir, right?
Only 10%.
Sir. Actually, sir, AEROs are there to assist the EROs. And
So ECR has notified the AERs.
And these AEROs are notified by Election Commission of India, sir. After notification only, they are appointed as AEROs.
Now, is it likely to be an anomalous situation in case out of these officers, those who are now sent to assist or advise,
Assist.
assist, that some of them will be senior to then AEROs?
Not the EROs, sir. EROs are all Group A officers of West Bengal Civil Services Executive or IAS officers.
They can report to the EROs.
They will report to the EROs
And they are only assisting, my lord, to
in the process.
ensure that no names.
In any case,
May I answer that, Millets? What they're telling is that, Millets, they're all Group A officers, etc. We have written 5 letters to them saying EROs are quasi-judicial authorities. Please provide us either SDMs or SDOs who are revenue officials who have been experienced in passing orders after adjudication, etc. This is what we wanted. What they have done, Millets, they have given us 64 of them. The rest, they have only seen the pay parity. For example, engineers from all walks of service. They have given us saying these are Group 1 officers.
No, they are
but
not-
we wanted.
they are not servants or the revenue officers.
They have nothing to do with the whole thing. They don't have any process at all. Miller's objections raised and they have to pass a speaking order. That has to be challenged in an appellate forum. For that purpose, 5 letters were written. Please, these are the officers we wanted so that they could adjudicate and then the rest of the process could take place. They have said during elections, these people were deputed. During elections, they don't pass orders. In SIR, they need to pass orders.
Election duties are something different.
Entirely different. Now they say these are all approved categories in the context of elections, not SIR. We are specifically asked 5 times. This is the role they have to play and they have not given. Now, Millets.
And
Yes.
let us now try to solve this where
Yes.
stalemate must go.
Yes.
One thing we would like to very clearly that whatever orders, clarifications, interim direction may require, we'll have to issue. But we will not allow to create any impediment in completion of SIR. It must be very clearly understood by all the states
That's
and the
correct.
state authority. Now, just to remove this stalemate, now that you have got another bumper draw of this 8,000 something officers, whom might be some of the officers are those who have dealt with in their services. Either they are, say, like sub-divisional officers, civil SDM as they call, or they might have held the position as BRO, revenue officers, or whatever designation nomenclature they have.
May I just add only one thing here, Millets? Let them provide the nature of work they have been discharging. In the list, a revised list they could give by evening, vis-a-vis all these 8,300 people, what is the functions they have been discharging? If they draw from various walks of life, we need to know what they are because my lords may can appreciate.
If you like head clerk, upper division clerk, inspector.
Department, yeah.
Yes, ma'am.
Land and Land Reforms Department. Mr.
Yes, Millets.
Naidu, please
Yes.
go to the second last column.
Yes.
The department is specified.
Yes.
You see L and LR.
Yes.
Land and Land Reforms Department.
This is the department, but the role that have been playing there, we don't know.
So you see the designation, law, LDC.
Yes,
That's the lower division clerk.
Low division clerk.
Sure. So they do office work.
My lord may kindly appreciate. Now we are coming to first Millets.
In any case, ERO and AERO, you have already notified.
Yes.
Unless you find them, some of them not really up to the mark in the sense that they do not have the quasi-judicial experience and they need to be replaced. And suppose you have some officers available here in this list,
Yes.
with whom you can replace, you can do that exercise. Number 1. Number 2.
May I just interject?
That's very appropriate,
With your
Millet. That's what
permission.
our intention is.
Millet,
Now
with
they
your
have
permission,
provided
may I just
8,000 Group
interject
B
here?
officers.
May I just interject?
EROs and AEROs
We are not
can have
seeking
from that pool.
replacement of EROs and AEROs, my lords. That's been notified. We are only concerned with the micro observers
No.
who are being
Right, that's
substituted.
not correct.
That's all this is.
I'll answer.
We are coming to that point.
Yes.
The second point will be that because this anomalous situation of senior or junior might arise.
Look, these will be only assisting or replacing the micro observers. Now look at what the micro observers there.
May I answer that, my lords? My lords have very felicitously observed that from this pool, I can as well replace EROs and AEROs because I want SDMs and SDOs. They cannot have any objection. Once they have provided a pool, millets, I wanted competent officers. I can give one illustration. When somebody defies my order, yes, please let me complete. I can answer.
That is nothing unfair in it.
Yes.
Mr. Diwan.
Yes.
Because once the officers will go, they are all on deputation with ECI.
Yes, yes.
Election Commission can decide that.
Look, if they want to draw on this pool for replacing an AERO, I am not going to stand in the way. My respectful submission is that these micro observers, because the whole, what's our apprehension? I'm going to come to that. What is the purpose of this name mismatch? It's just to purge the entire voters,
We'll come to that.
electors. That ought not to be allowed on a mass scale. That's our anxiety.
We'll come to that, millets, when we cross the bridge.
Yes.
We are coming to that part also.
Yes, millets.
So first you can do that. There is no difficulty. You can replace your AEROs whom you find that they do not
And EROs also, who are not SDMs or SDOs.
whom you find that they do not have enough experience of performing this kind of quasi-judicial.
Precisely.
I'm not saying it's a quasi-judicial, but kind of quasi-judicial duty.
Exactly.
Because they have to apply their mind to the objections, pass a reasoned order.
Yes.
Right? That's one done.
That's one thing.
Now, second thing comes to this micro observer.
Yes.
Yes.
Micro observer is basically a team created by you for the purpose of assisting the ERO and AERO. Right?
Yes.
Assistance for what is the nature of that assistance?
I'll explain, millets.
Yeah.
Millets, these micro observers, they sit during the process of hearing and they notice all the objections given or documents given, everything, etc. Then from the ERO or AERO, whoever conducts the inquiry, they collect them, they scrutinize, and on the website, they say they are perfect, you may consider. If they are not perfect, please relook into that. This is the advisory role they play.
To take this final decision that these objections are, say, perfect, that the name, there is no mismatch, actually it's the correct name. This decision will have to be taken by the ERO or
EROs.
ERO.
He has no role to play.
So they are only assisting them.
Exactly.
It is something that order we will have to pass them, but both sides we are hearing.
Let me submit, millets.
Right?
Now let me submit.
So,
Now I'll submit, millets. So once they all come to me, they needed, as we did with the earlier batch that's presently there, that's micro observers, they need at least 10 days training to be given. That's what we have done. They needed to be trained with regard to document perusal, the scrutiny, all these things. They have to do that one. Now, millets, the hearing was over. Out of 1.51 crores, barring 14 lakhs, the rest hearing has been completed. The present batch, they were present during the process and they are scrutinizing that one. Now, millets, if somebody has to be there, they can only supplement because they were the people who were present during the course of hearing. Now they are scrutinizing the documents. If I have...
even in those cases where the process of filing documents is complete, say 1 point something crore you are saying, the documents are yet to be scrutinized in those cases also.
But hearing, they had the advantage of being present and collecting them.
Fine.
Yes.
Fine, understandable. Yeah. But the documents, final yes or no, with respect to acceptance or rejection of those documents is yet to be taken.
Yes, Minister. In the process. May I submit in the process? It may be done in a day or two.
Obviously, in the process. So if these officials, which are being now sent, if they join tomorrow morning to your official, let them also go through those documents and give their assistance to you.
May I submit, Minister? Yes, I'm coming. It's not just the one. I'm just coming. Yes, Minister.
It will enhance the quality of the decision-making process.
Yes, Minister.
Because somebody...
Precisely.
Decision is to be taken by the ERO and AERO.
Yes, Minister.
By taken by me and my brother.
Yes, Minister.
Arguments is your side.
Yes.
So instead of argument, it will not be an adversarial kind of adversary. Here somebody will say, I know Bengali, I know this reason, I know a little bit knowledge about this area. Here somebody, instead of DUTTA, somebody writes DATTO. Right? This is only something. Somebody may assist you and it might be a very convincing argument for you. You may accept
Actually, my lords, for my lord's kind consideration, will give illustrative cases where we have flagged it, saying that one, there is logical discrepancy. It's not been divorced from any common sense. We have found that where it is irreconcilable, we have employed a software which can as well identify the spelling mistake, and it has ignored it. It has ignored it. Only when it comes, please, yes, let me complete. Yes, my lord.
Ground reality.
Yes, ma'am.
What is happening is there definitely may be logical discrepancy, but also with the application of the software, there may be a much wider net to which notices are going.
Yes, my lords.
It's creating a bit of a.
Could I send my lords a list? Two lists we have prepared. As an example, we have prepared two lists. My lords could see where it's been flagged as to the discrepancy, where it has accepted, notwithstanding the minor variation.
Saying a difference of 50 years for grandparents.
Yes, my lords.
Would be a logical discrepancy.
My lords, what?
2020
Yes.
being a reproductive age.
Yes,
Will 50 be a good window?
My lords, we kindly appreciate. All that we wanted is when it comes to mapping, whatever the details available in 2002, if you replicate them here, no questions asked.
We cannot restructure it. But
No.
program that you have put for the your software to work,
Yes, my
in
lords.
certain cases may have a policy challenge.
Yes, my lords.
You're saying that the
That's why,
difference
Millets.
of 20 years between parents and a child is a question because in India it's all cannot be an underage marriage. But these are not real ground realities.
Millets, actually, what we have done is that, Millets, each
Probably
elected was
it
required.
happens to be in this, referring to this age or gap in age is maybe that you are trying to identify that actually, if they are actually found to be really grandson and grandfather, then you can't have any objection. The only thing that this is only one of the tool to identify whether actually they are grandfather and grandfather.
Actually, Millets, actually, it's only tip of the iceberg. I'll give an illustration. About 200, in two instances, 200 voters have traced their mapping to single parent. Is it possible? Yes, we have given the statistics.
ECI after.
Yes, Millets.
We have seen that there are persons with 50 grandchildren. Definitely you have a right to issue a notice.
That's what we have done.
Person having 5 children, 6 children, you are issuing notice.
Millets, what has happened, Millets? My lords, may I appreciate one thing. If 2002 mapping corresponds with this one, no questions asked.
Yes,
about
questions-
5.6
Questions asked.
Millets,
Questions asked, sir.
when 5.6 crores has passed the muster, we have got
Notices are for mapped people.
mapped incorrectly. May I submit, Millets, with great respect? Mapped incorrectly. Had there been
Traceable to mapped people.
Had there been syncing perfectly, no questions asked. Once it's been
That's
incongruous.
perfectly, there the tools that you have applied to the software appears to be very restrictive tools. They are eliminating natural differences.
Yes, Millets. Could my lords have a look at the papers we have given as the examples of where it's not been flagged, where it's been flagged?
As is indicated, surnames are of various forms. Roy, Ray.
Millets.
These
Let
are
me put it this
There
way.
is a common practice of Kumar being a middle name in Bengali households.
Yes, Millets.
So you have a Topon Kumar Rai.
Yes, Millets.
On Rai. Now the omission of Kumar in notice is being given.
Yes, Millets. May I submit, Millets? The whole thing has arisen on one concept.
This is तथा का नाम है प्रोबेंदु नारायण सिन्हा.
Yes. Notice.
2003, your name is Yaya. You sent to do. How the hell is it the same?
Because they translated it and they did a CSV
So you're telling me the
translation.
actual Bengali is very something else?
Yeah.
So check and say. Give examples, right, sir? Check these names. And
This K. Krishna, Bala Krishna, it's bad translation. And notice, it has to be that. Baki must be a duck name, not a pet name. Yeah, the reality is
we have to give against his explanations for past criminals.
I just submit, Millets. Kindly have a look at my notes. since an issue has been raised, Millets, kindly have a look at my notes. Page 39 of my notes.
May I just complete my brief submission?
Yes, yes, well, surely, we are only trying to find out that if we can,
Please note this also.
no, if you want to make submission based on that.
Millets, since they have said, making a mountain out of this molehill, Millets.
Well, so I think we should be heard first
Yes,
on this.
Please, let me
because-
complete, then you can have your say.
Right now, on the continuity of what was argued on the previous date of hearing and what has emerged today.
Yes, Millets.
The last date of hearing was, they were since objecting to the micro observers brought from different.
Let them complete, Millets, I'll answer.
Yes.
No, we are not on that point. We are simply on the point which you are right now saying, that now these 8,500 something people are there sending. Let them report tomorrow. Let them also join the team of that assisting.
They need to be trained, Millets. Before that, the precondition is they need to be trained. Without training, they can't. They can't make head and tail of it because they are not experienced in that field. They have to be trained, Millets. By the time, the whole, my lords may appreciate, it's a time bound one. I need to just finish by the deadline. And then, Millets, if they have to be trained in the next 10 days, it's not that we're doing it for the first time for them. The previous batch too had 10 days.
Mr. Naidu, outsiders, officers who are not aware about the local conditions, you might require to train them, that they have to understand. Here it's not the question, you are not depending on them in the sense that you have to take a decision as per their advice. Decision your officers will take. You will simply say that this is the matriculation support certificate. Here it is saying that some, say, let us say P. Narayan Sinha, and the son is written only Prashant Sinha. Father is suppose Narayan Sinha, the son is only Prashant Sinha. So somebody can point out that yes, in the as per the certificate, he happens to be the son of so and so. Maybe that the son does not write Narayan. That's all. Then you can think that whether what is the decision to be taken.
Well, if I'm not contradicting, let me submit humbly that an untrained professor is less skilled than a trained clerk. Sometimes they have more knowledge because they're practically hands-on experience. Here, we'll take them, we'll see their profile, we'll see their suitability. We have this migration as lordships have permitted when it comes to EROs and AEROs.
So,
remaining, if they are good enough, they can be trained within short time, and then we can employ to assist in the process. We're not excluding them, but we need to have the list. We'll scrutinize them, find the suitability, then we'll earmark which people we need to have. Because we have already had about 6,500 people. If they wanted to supplement, that I need to have. So that let's let them provide the details. Now they have done that one.
List is coming to you today itself.
Yes, Millets.
Let them report tomorrow morning.
Yes, Millets.
Then you can have some whatever bare scrutiny about their profile.
I need to, Millets.
Then you can immediately associate them. You see how worthy they are.
May I submit, Millets?
It is something today we are saying on judicial side that you require 3 years practice to become a judicial officer.
Yes, Millets.
There was a time, no, you are not required. You come pass out law, you can.
The experience proved otherwise. That's why my lords have reimposed that.
So these things will continue to vary. You see them for how, to what extent they are useful to you. Simultaneously, you can start imparting training also. Training in the sense that you will sensitize them that this is how you have to scrutinize the document. That's what the training. You do that also.
Millets. Then next thing, we need to give them ID. We need to give them a portal access. All this logistics takes place, Millets. My submission is that, Millets, let them report tomorrow. We'll scrutinize. Kindly have it either day after tomorrow or the next day. We'll come back and we'll report the position. If they are suitable, we are drafting in only to assist. Let it be, Millets.
May I just complete?
They can't just give it now and say that tomorrow they start functioning.
Okay,
so let it be. In 48 hours, we'll get back to your lordships, whatever feedback we could have about their suitability.
I'll just state my points now because we are pressed for time. So I'll just state my points. My primary position is that as far as these so-called logical discrepancies insofar as name is concerned and name mismatch is concerned, the default position ought to be that these people cannot be excluded. There has to be, sorry.
Mr. Diwan, principally we are saying that if somebody only because he spells the name with a different words.
Please add, Millets, please make a direction to that effect.
We cannot issue a direction because this will amount to preemptive direction to them to interfere in their functioning.
Millets, but I want to show you what they have said. I'll just take your lordships on that. Because these are on the 2002 list.
Yes. Notice is something different. Taking a decision is altogether different.
Sorry?
Taking decision is altogether different.
No, I understand.
Notice
So-
has been issued based upon some AI app or
Absolutely.
whatever it is.
Absolutely.
Now the person come, look here, how have you doubted my identity? I am same thing.
Yes.
How can you doubt my identity?
Yes,
Certainly
correct,
come.
correct.
So let us see after these verification of these documents,
Yes,
how many these notices are dropped.
yes,
Suppose
okay.
only 5%, 2%, 1% are left as doubtful cases.
Right.
Your argument will also be in a different.
Yes, you're right.
But if suppose in 80% cases, these
Yes.
objections are turned down,
Yes.
the argument will be the same as you
All
are
right.
arguing today.
All right. So fair enough. So Manoj, then in which case, Manoj, first of all, I agree with the observation made. That's a sort of a logical manner forward. I have no quarrel with that. They can come back. The issue, I should. Just a second.
No.
I should just mention one point because it may not dovetail with the timeline and the sequence which your lordship has indicated because we are trying to adhere to this. 14th of February, they are declaring the final list. 14th of February. Now with 10 days training, there's going to be no time to train these people. So the fait accompli which we are going to find is that on the 14th of February, there will be a final list. We won't know the exact points which your lordship said, whether it is 80% have been accepted or 90%, or there's been a wholesale rejection. There will be no question of pursuing an appellate remedy, because thereafter, as your lordship knows, that once there's a final electoral roll, there will be, and a notification follows, say, for the elections. That's the end of the day.
We visualized the situation and we made some arrangement in Bihar case. It's not that first time we are dealing with it.
Yes.
This kind of scenario situation had arisen in Bihar also, and we had introduced some.
So we don't want a mass exclusion, Manoj. I think that's the sentiment also this court's concern. Now, Manoj, may I go to my second point? So, Manoj, as far as name and these other mismatches which your lordships have correct regarding number of progeny and the age, according to us, if so long as it's just a minor number which they eventually post screening come up with for deletion, it's one thing. But if it's going to be a mass exclusion and a purge, then it's an exercise where, Manoj, the computer is a bit of a tyrant, is my respectful submission. That on the basis of some program and on the basis of some bias, you exclude people. So, Manoj, that is my first set of submission.
Only speculative, Mr. Diwan.
Yes, but Manoj, my apprehension is, all right, fair enough, Manoj, I've made my point. Now, Manoj, go to my next point. So this is, Manoj, as far as the micro observers are concerned, I want to make just 2 points. The first is just take up, if your lordships would, Manoj, there is a rejoinder, just have a look at the rejoinder affidavit that I have filed. 2 documents I want to show you. Which one?
Let's take it on.
Yeah. Your lordship will just take up my rejoinder on 2 pages.
In Dola.
339, 340.
In Dola Sen.
Filed on 7th Feb.
I give copies here. Oh, so Manoj, maybe I can be quicker. Your lordship has the note which I handed over last time. Your lordship has that note, correct? So it's the same document in the rejoinder. Please go directly, if your lordships would, to page 19, 19.
19 of today's note.
No, last time's note, Manoj. We have now placed it on affidavit.
Yes, yes.
Your lordship has page 19. Yeah, appendix 4.
19 is this.
Is appendix 4.
Yes. Your lordship has.
Handbook.
Now, this is the Observer's Handbook published by the Election Commission of India. Your lordship will find that on page 20 as well. Now, please see the role of micro observers. This is very important. Now, this is their own manual which I'm pointing to. Please see page 21, if I may just place it. Micro observers. The employees of the central government PSUs are appointed as micro observers. The micro observers are expected to observe the polling process on the day of poll. They are assigned duty in the polling station. They shall be part of the polling team and shall be seated in the polling station. They are to be present in the polling station before the mock poll starts. They shall report about the poll day in a given format. Report of micro observers. Micro observers are to be trained by the observers 2 days before the poll with the help of the RO and posted in the polling stations which are critical. Therefore, an arrangement is required wherein micro observers are stationed at a central. So now, Manoj, this is their manual. Now, how if this is a micro observer on a polling day? I'm sorry.
This election, this manual.
Yes.
This observer's handbook
Yes.
pertaining to the conducting the elections
Precise.
for SIR.
Yes, but that's the point. There's no other role for a micro observer, my lords. There's no statutory basis. Now see.
Once the micro observers are appointed in an SIR process,
Yeah.
Mr. Diwan, that we will have to give this responsibility or this power to the ERO.
Yes, absolutely. No problem. The ERO can certainly exercise this power, but not a micro observer. Now, why the apprehension?
Micro observer, you are right. Micro observer cannot take a decision.
You're right. I'm obliged. Now, my lord, just take up my IA 26838. Just take up IA 26338.
Those who take decisions
Yes,
who have been crying foul, saying that, and please give us competent officers.
Just a second,
EROs
just go to
and
page
AEROs,
106.
They have never provided. On a non-issue, they would like to make the whole attention. Ultimately, the orders are passed by EROs. And we wanted competent officers. Even in this
Now, look
list,
at your
even in
lordship
this
has-
list of 8,300 millets, I don't think there is any SDM or SDO. Who
Your lordships may just go to
kindly
page
direct them.
106.
Please kindly direct them to provide these officers who ultimately pass the order.
Will you get 8,000
I'm
SDM?
completing my micro observer. I've just completed my point in answer to the Chief
From the
Justice's
government,
observation.
from the government rank and file only we want.
Yes, please
Not
just
from
go to page
outside.
106.
And they don't provide that one.
Will you just see page 106?
Yes.
And we'll give the statutory base also, millets, for micro observers.
You'll have to make 8,000 districts in Bengal if you want 8,000 SDMs.
Your lordship has, my lords, page 106. It's a screenshot
Yes, yes.
of 26838. Your IA 26. Now just go to the last, to go to the bottom screenshot, my lords. ECI net login for micro observers. Elector present for hearing, yes, no, and action. I agree with your lord.
There is
Sorry.
wrong document has been given here.
Petition,
Who's the rejoinder?
petition, rejoinder.
Dolas and rejoinder.
Can you meanwhile point out what is the document?
Oh, sorry. I.
I get 26.
The screenshot gives, I mean, it suggests that the micro observer has been given authority here to agree with the decision of the ERO. Just please see this. How can you have a application like this?
Millets,
Just
that's been
look at this.
changed. That's been changed. That's been informed. They're just flagging on that one. That was long back changed. Now they have got to only click
gross.
one button. We have provided that one too. An argument of prejudice without any substance.
Yeah, this is their own application over here.
We have changed it.
Changed it.
So if, so let us see, I think, anyway, we can, sure.
Show me that.
Yes, please see the last screenshot. It's on page 106. And at the foot, there's a heading. ECI net login for micro observers. Elector present for the hearing, yes, no, action. I agree with the observation of the ERO or AERO. And I do not agree with the observation of the electoral, of the electoral officer or the additional ERO.
And the ERO is a.
That, you see, Mr. Diwan, is something like some lawyer arguing that, all right, I endorse the view of the.
No, but when this is
given,
given,
Millets, to cut short the whole controversy, cut short the whole controversy, Millets, kindly have a look at page 76.
That is the reason lakhs of cases have
Kindly have a look at page 76, Millets.
been kept pending, lakhs of cases.
Millets, would my lords have a look at page 76 of my note?
Milord, let me
That
just
will answer.
complete now. Milord, I'll just complete.
Page
So, Milord,
76 of my note. Let me counter that. That's completely a false statement. Kindly have a look at page 76, Millets, of my note.
What is the note?
Kindly 76.
Yeah.
Page 76 of my note, Millets.
But why are we going to and fro like?
This is the role the micro observer plays, and we have given it. Kindly see, Millets. He has to click either of them. Does it amount to any way he's vetoing or taking a decision? Just have a look at it, Millets. 76. Submitted documents need to be reviewed. Go to the next elector. He could press either, but it doesn't bind the ERO. He has to take his own call. That's why we insisted that let there be a competent officer as an ERO.
But this is creating an extra election authority, my lords.
When I have got plenary
So
power,
anyway, I have now
need to
completed
have
my
the
point.
staff
I now
as
go
a
to my next
desire.
point. Milords, I go to my next point. Now, please just take up my rejoinder and just go to page 308, please. 308 of my rejoinder. It's a thick one, which we have placed. Now, this is a separate point. Your lordships, I think, were looking at it.
Where is that rejoinder? Was it given earlier? Yes, we got.
Yes.
Structure 307.
Yes.
Structure 307.
The document itself, my lords,
Structure 307.
begins at 307. Justice Bhatia. Now, this is dated 22nd January.
No. This is with the 7th February.
Yes.
Yes, that's the one. Correct. If your lordship is pleased to go to page 307.
307.
Your lordship has it?
Annexure Y.
Annexure Y. Right. Now, this is what they published or issued on the 22nd of January after your 19th January order. Your lordship may just note that. Now, please go to page 310. 310. They have a list there of acceptable identity documents for self, father and mother. Your lordship has that at page 310. So this is the list which they publish. Now please go, if your lordships would, please go to page 312. Now see the directions they're saying. Common observations as to why cases are doubtful and liable to be rejected. Your lordship has that caption. So these are general instructions being issued. Observation. Only Aadhaar and so-called family register SECC enumeration data submitted to be rejected and decided thereupon. So the default position in their instructions is that even if you have a family register and Aadhaar, you have these two items, still the general direction is to be rejected. Now look at the next one. Aadhaar and admit card. Now your lordships had mentioned about the admit card specifically in your 19th January order. Aadhaar and admit card submitted. No other document which proves linkage to either parent's date of birth, place of birth, if born in between 1st July 87 and 2nd December 2004 or thereafter, doubtful and to be rejected. General instructions. Look at the next page, 313. Birth certificate, admit card, caste certificate or self-submitted by born after 1st July 1987. No other document which proves linkage to either parent or place of birth, doubtful and to be rejected. And look at 6. Birth certificate, SIR extract of either parent, but name doesn't match of either parent. Name mismatch. No other document to be rejected. And ERO, AERO, BLO be under scrutiny. So wholesale, even if a person has two documents, leave alone one, their list, as your lordship sees at page 310, is one document. One document. They are wholesale issuing general instructions, my lords. So you're going, this is the idea is not to include, the idea appears to be to mass exclude.
Mr. Diwan.
I'll answer all these things, my lords. I'll answer, my lords.
Yeah.
We are not done yet, my lords.
Yes, yes.
I also want
Yes,
to make
complete.
submission.
Yeah.
This
Let it
interruption
be
goes on.
completed.
Some people maintain discipline, the others go on interrupting.
You know.
My lords, this preaching should stop
Yes.
from my friend.
Now, my lords, I'll just
Then don't interrupt.
Now, this was circulated. I'll complete.
nowhere done.
This was
And everybody
circulated.
knows that.
This was circulated under a WhatsApp message. This entire PowerPoint at page 326 on 23rd January 2026, after your lordship's order of 17th January. And the reason I mention this is that in their reply affidavit, they make an evasive denial saying you haven't produced any document in support of your claim. So we had to annex this particular document. Now, my lords, your lordships may just pick up my note, my lords, the note which we had submitted on the 4th of February. Just take that note for a moment. Which one? Which way? And please go directly to page 22. Yeah.
Last word.
Yeah.
Last
Yeah.
word.
Now, this is suggestive of the extra legal role being given to these micro observers. Look at page 22 from their dashboard. Your lordship has appendix 5 written on top. Well, just my previous note which your lordship was following.
Page 22.
22, appendix 5.
Appendix 4.
Your lordship has it? It's a table. It looks like this.
There are so many documents.
But I had handed in a note on the last occasion and then we replaced it.
Yes, you can refer to now.
Your lordships on page 22 have appendix 5?
Yes.
Yes. Now please see their dashboard. Notice delivered by BLO, yes. ERO, AERO action found okay. Role observers observation pending for observation and micro observers observation pending for observation. So our serious apprehension is that even after the ERO and AERO has found it to be okay, you are giving the trump virtually to the last say, to the micro observer. So this doesn't seem to be a fair manner of proceeding.
See, the ERO and AER also,
Have found okay.
that much, they are expected to wait for the observations of these two subordinate
That's it.
officials and then take a call.
That's it.
But where's the question of
pass it
taking
on.
the question I say is, where's the question of taking a call? Where?
Taking a call in the sense that you have two opinions, assuming.
Yeah.
One says that these documents are genuine. The other says the document, no, this cannot be reliable.
Yes. Yes.
ERO is the final authority to take a decision.
Yes, absolutely. So, my lords, please, my lords, a direction to that effect that the ERO is the final decision to take a call on this.
Millets,
And
nobody has
that will
questioned. Never has it been in controversy.
The process, my lord.
It's ERO who is the final authority. And ultimately, he takes a decision.
Controversy about that.
It's a non-issue, Millets. Ultimately, he takes the decision. That's why we have written 5 letters. Please give us competent officers
That is
with experience. They never provide. They themselves say that we have given Group C officers. Now they say this is the duty.
If all of you agree, we will pass a short order, short but little giving explain.
I have one submission, just one
I have
submission.
one submission, my lord. Kindly.
I
My lord, I have one submission.
I waited for Mr. Devan to
My lord, I have
finish.
one submission.
Just just 1 minute.
My lord, I have
My
one
submission is only this. In the spirit of what fell from your lordships, that these 8,000 names are being given, they will carry out the exercise, etc. In the spirit of that, since 14th February is coming as a deadline, that final list cannot be published. In my view, if the final list is published, then the entire thing is a fait accompli with the exclusions. So as far as the 1.36 crore have been excluded, they will remain excluded and we won't have anything to say at that.
My lord, I have one submission. Just kindly allow me.
My lord, can I make a?
Point is this, my lord. This point is this. I am not restating their points. The point is this, my lord. Bundle of objections are being filed by some individual without disclosing their names, identity. Fair enough. But at the time of hearing, the objectors must remain present at the time of hearing. Otherwise, how do I know
We are
whether
going to regulate their internal functioning. So
no, internal no, my lord,
Law says,
to all of you in a 32.
my lord, kindly see the rules. Kindly see the rules. My lord, can I read?
Lord, can I make a
Number 42, I raised
Lord, I-
provision.
Lord, I am in a different writ petition, my lord, where I have a contrary point of view.
in item number 42, I raised a little issue, my lord, regarding other, my lord, I know the lordship judgment
My lord, kindly,
is resolved.
my lord, just I read.
I know your lordship judgment is
Just
resolved
I
in
read
item
the rules.
42.
Just I read the rule 20 of the, my lord, the registration of elected rules 1960. The registered officer shall hold a summary inquiry into every claim or objection in respect of which notice has been given under Rule 19 and shall record his decision thereon. 2. At the hearing, the claimant or as the case may be the objector and the person objected to any other person, when the opinion of the registered officer is likely to be understood to him, shall be entitled to appear. Therefore, an objector who is filing 1,000 objections without disclosing his names, like an anonymous complaint.
I'll straight
I
away
must
answer.
know when I have been asked to appear, who is that objector who has given the objection? Is it completely false objections but only for the purpose of, my lord, the harassing us? This is the, my lord, this thing is going.
I'll answer straight away,
my lord.
That's completely off the record.
Anonymous complaint.
It's never been an
Lord, put your lordships.
Sorry, item number 42, I have very limited issues, my lord.
I don't get a chance, my lord, to make a submission. What do I do?
Reading his address like this, 5/1 West Bengal. And he is asking to delete the name on the ground of no Indian citizen. Whether the election commission will have any authority to decide who is a citizen.
We are not commenting on that.
My lord's a non-adversarial suggestion.
This is the way it's being done. It should not be.
May I make a non-adversarial suggestion? May I make a non-adversarial suggestion? I'm 40.6.
Effectively, what has happened, my lord, the police has got 2 persons who was carrying in an ambassador nearly
Please don't make.
Nearly 1,500.
Item number 40.
Manoj.
In item number 42, I have limited issue.
Manoj, a non-adversarial suggestion. Manoj, I'm in 40.6. Manoj, the statute contemplates this. The SIR, the problem which is arising on both sides is there's a looming deadline and there's a problem. Manoj, the Act itself provides 21.3 that you can carry out the SIR, and the proviso says that there's no time limit given. Proviso itself provides that if till then the existing electoral roll remains. I just leave it to Manoj.
In item number 42, my lord.
We are 40 points.
Issue, my lord. Item 42, my very limited on other card. I know that your lawsuit there is reserve, but what happened in Bengal, my lord? The Election Commission has included other cards item of 2012. The ground rate is what, my lord. During the submission of the claims, the electoral officer cannot.
Mr. Diwan has already indicated that. Mr. Diwan has already.
Yes, Mr.
My lord, can I, my lord, the writ petition number 1216 of 2025. My lord, that was a writ petition filed by an association stating that the election commission must be more involved in the deployment of safety and for the safety of the officers, my lord, in the course of conduct of the SIR also. Now, my lord, the question of conduct of elections comes a bit later. Now, my lord, I have filed there is a detailed additional affidavit which has been filed by the Election Commission pointing out that they have taken steps, but it has not proved to be adequate and sufficient. And therefore, what they say is that they are in touch with the government officials, but they have not been able to get the adequate number of security forces deployed. Now, my lord, there is also an indication, my lord, in the affidavit that there has been large-scale, my lord, burning of Form 7 objections in several places. Now, what ultimately, my lord, it has come to, insofar as the Election Commission is concerned, is that, my lord, they have given illustrations of, my lord, wholesale exhortations by members belonging to one political party, my lord, stating that these objections will not be permitted. Now, my lord, at one point of time, they even go on to say that it will not be possible to consider the objections unless, my lord, the objections are placed on record, my lord, before the officer who's considering them. Now, my lords, therefore, we have filed an IA, my lord, in this, and we have these are the reliefs, my lord, which we have
We have already issued directions on 19th January.
No, my lord, the directions are what we have stated, my lord, in this.
No. Directions are to the Director General of Police, to all the Superintendent of Police,
Correct.
to the Collector.
My lord, apart from
The
that.
Election Commission finds that despite those directions, the
Yes.
right order
Yes.
is not being well maintained.
Yes, my lord, put your lordships, my lord, these are the.
It's your Election Commission not powerless.
No,
We have,
no,
we
my
have
lord,
filed a
that's-
detailed counter.
Yes.
process is
And
over.
detailed affidavit,
Bringing
my lord, what we have,
notice
just a moment.
The
Mr. Naik.
defiance and
My lord, these have,
Concern.
This process is over, my
my
lord.
lord, I'll just complete this. My lord, this is what I have prayed for, my lord, in the IA. Let the Election Commission take note of it. Lordships may consider it. Let the state also say what they want to do. First direction would be I've asked for is direct the Election Commission to extend the time for filing claims and objections by a period of 14 days because our objections have been burnt wholesale, my lord, in several places. It will go to, my lord, it will go to the advantage of those persons who have claims as well. But this time frame, my lord, if it is 14th of February, it proves to be completely inadequate. The second, my lord, we have also said, because this Election Commission is not getting sufficient cooperation from the local police, what we have said, let them respond to that. Direct the Election Commission to deploy central paramilitary forces and depute police officials from other states to the SIR centers to ensure their impartiality. Problem is, my lord, my learned friend has been
to my argument.
that the object
It's just contrary to my argument.
That's what.
Management
Lord, I am appearing for Union of India.
I have taken cognizance by writ petition.
Therefore, one
Lord,
gentleman.
if my argument was the same as that of my learned friend, I need to simply say that I adopt his argument.
Both of you are on the same page that there is more time necessary for verification and preparation of the for the purpose of
Correct, my lord, correct. Therefore, my lord, whatever it is,
And my lord,
let
the
the election
statute,
commission
my lord, the statute does not
and say
contemplate a time.
that we are extending the time.
Statute itself does not contemplate.
Statute doesn't contemplate, but that has to be done by
And
the
your lord-
summary.
Yes, but my
Your
lord, the
lordship's
FIR,
order,
Timeline, nothing
Milord,
is finalized.
lordship's
Milord,
order
900
dated
voters.
91 covers his
I want-
concerns,
Doesn't
my
cover.
lord. It covers.
It's a completely different thing.
Comprehensively.
only one
Petitions
State government
filed
doesn't,
with them.
state government doesn't want anybody to
Filed a response. my
get
lord.
another, some more time to file objections.
Can I mention
Filed a
something?
comprehensive response.
Where
Addressing
the
his
choice is
concerns.
that you want us to pass the order in court or we go inside and.
My lord, can I have 1 minute, my lord? My lord, I appeal for Union of India.
Yes, Mr. You can also join.
No, my lord, I'll make only one or two statements, my lord. I am not long. In Mr. Giri's petition, Union of India is joined as a party. Now, there is already one detailed affidavit filed by the Election Commission of India a week before, and one affidavit is filed yesterday. My lord, one constitutional body intimating the highest court of the country, your lordships may see the contents. My lord, it is really, really alarming. Your lordships may take cognizance of it and, my lord, pass some remedial directions.
That's what I want to take your lordship to that
we are
affidavit,
counting.
additional affidavit filed by the.
Please go through that affidavit, my lord, otherwise it would be
Somebody must
have linkage to all the.
But I joined, I
justice,
agree
my
with
lord,
Mr. Shankara Narayan, there must be some discipline in these matters.
In this petition, we should be made party. We are
Commission of India.
arguing here. We have not been made party.
Powerless. They should have, they can always ask for the, whatever central forces, paramilitary forces, state police, more state.
Well,
My lord, can we see the affidavits, my lord? It's not just
state
central
government's
forces.
response in their
Why
rejoinderies.
it's not just
Police is
central.
my subject, state subject, you have no control.
Correct.
They refuse to register FIRs when I have requested.
That is.
And some officers, AEROs violated the directions. We have said that they should be replaced. They have not done that one. Certain
Your
good
lordship's
officers,
order
they have
directions are,
transferred.
my lord,
We have said,
violated.
don't transfer them.
Yes.
They say that you have no control. We have given every instance, every day, the
Well,
leaders.
My lord, there is
whoever that-
wholesale burning of
You would
Form
be
7
killed.
objections.
You would be killed.
The step.
FIRs are not registered.
All the videos.
Document.
There is violence
FIRs
on the
that have been
street.
filed. They've
In
also-
SIR hearing, there is violence on the street.
And no safe
What do we do?
officer there.
Concern has been
Violence
addressed.
is instigated
The
by
counter.
leaders.
Please
my lord.
see, we
That
filed
is
two counter
really
affidavits.
unfortunate.
Counter and an additional response.
Even CEO is not spared.
Please take that.
That has
Please
been
take that up,
lodged.
my lord.
Please go through that
We have
affidavit.
filed
my lord.
everything.
My lord,
Along
a
with
message
the
will have
counter,
to
we have filed all the complaints.
It's counter, my lords.
We have filed all the complaints.
My
Lord,
may
a
I just-
message must go that
Government's
Constitution
counter.
of India applies to all states.
My lords, may I just take you to page
My
3?
lord, leaders of a political party exhorting that objections
Lords,
may
we
be,
can't-
objections may be,
you are
man,
no
you
Mr.
can't.
Giri.
Therefore, please let me complete it. Let me complete
Cannot
my
read
submissions
any
with Guruswami.
Right.
Leaders of political parties exhorting that objections be burnt. There is
My lords,
my lord, pervasive violence on the street.
We have probably-
Objections are not being heard. Quasi-judicial function is not being discharged.
And
Lord, if there are claims, there are objections. My learned friend says there are 1,000 objections. Therefore, my lord, they want the objectors to be there. Let them be there.
crore.
But if they are,
Be there.
if the objections are being, burnt, Form 7 are being burnt, my lord, how will those persons come there? They are being destroyed.
1 crore objections.
My lord,
have been
all
heard.
anonymous-
Constitution must apply to all states in the country.
I just take you to page 3 of
That
the counter.
message must go, my lord. That message must go. With all
My lord,
humility at my command.
in a place, my lord, in a minority constituency, just 1 minute, my lord. In a minority constituency,
The objectives will appear.
my lord,
Burn the objectives also.
just kindly say,
Milord.
in a place, my lord, where the minority remains, Beloved, if there is 1,000 voters are there, 950, their names in the logical discrepancy, again in the objection. How it can be possible, my lord?
My lord, there is
How
one
it can be
application,
possible?
My lord. My lord, there is my IA in item 40.2, my lord, my IA for interest.
All right, thank you very much. Now,
No, my lord, can I issue notice in that way it is fresh IA, my lord. And in fact, my lord, it is on behalf of the Vice President, Akhil Bharat Hindu Mahasabha.
continuation of
Before passing any order, please go through those replies and take care of the situation.
Yes.
That's the
Yes.
only thing I'm requesting.
See the state government's response.
Yes,
It should be made part of there.
both.
That is, my lord, unheard of in the Indian constitutional history that she has come forward and filed petition before this honorable court and
What
she
is,
also appeared.
what is the unheard in it?
No, my lord,
That
never,
shows
Lord. In
the
the
faith and
Indian
trust in the system,
constitutional
that's all.
history, never
She is having a right to file a
come
petition.
against the constitutional
No,
body.
there is nothing to
What is that? She is having a right to file a
Against
petition,
constitutional body and
like an ordinary citizen.
So we want that, please don't politicize these
No,
issues.
therefore, my
We are
lord,
not
can
very
my
fond of this.
my lord, in entire my lord West Bengal, the demography is changing, my
February
lord, and we are in this
2026. Now please stop.
petition.
4th February 2026. We have heard a battery of senior counsels on behalf of the state of West Bengal, its chief minister and other petitioners in the connected matters. Similarly, we have heard Naidu learned counsel for senior counsel for the Election Commission of India. Senior counsel for the on behalf of the Election Commission of India and other relevant senior counsels representing the parties. Mr. Tushar Mehta from the Solicitor of India has also assisted us in the matter in petition in bracket civil number 1216 of 2025, and he has made a pointed reference to the affidavit filed by the counter affidavit filed by the Union of India
Two
and
affidavits, man.
Election Commission.
And two affidavits by the election.
By the Election Commission of India. Next paragraph. It may be noted at the outset that in the previous date of hearing, that is on 4th February 2026, Ms. Mamata Banerjee, the Chief Minister of the State of West Bengal, also appeared along with her senior counsel in a writ petition number so. The writ petition filed by her, mention the number of that. During the course of hearing, when an objection with regard to deployment of micro observers by the Election Commission of India was raised, it was pointed out by senior counsels representing the Election Commission of India that despite repeated requests, adequate manpower was not provided by the state government. Instead, on manpower of the certain categories of officials who were competent enough to discharge the quasi-judicial stroke assisting duties were not deployed, were not being provided stroke deployed by the state government to the Election Commission of India for completion of the SIR process. On this, the Chief Minister of the state made a statement that she was willing to provide the adequate manpower, the government of state government officials who are competent enough to perform these duties. Next paragraph. In purported compliance to the statement made before this court, we have been shown during the course of hearing that on February 7, 2026, the Chief Minister, the advocate in writ petition number 129 of 2026 informed the senior counsels for the Election Commission of India on February 7, 2026 at 11:50.07 a.m. The state government is ready and willing to make available 8,505 numbers of Group B officers of the state government and or its instrumentalities for the SIR exercise in West Bengal. Next paragraph. When we inquired from Shangduan Senior Counsel, subsequently, the mail, the Election Commission was asked to confirm whether about the requirement to the Election Commission so far, as they were awaiting the consent of the Commission in terms of mail dated February 7, 2026. So, however, during the course of hearing, a list of 8,505 group strictly to be Group B officers working in different departments of the state government, has been handed over to Shri Naidu, along with Senior Counsel representing the Election Commission of India. That list has been also placed on record before us. Next paragraph. In order to streamline the ongoing process of SIR and also with a view to address some of the apprehensions being expressed by different stakeholders, we deem it appropriate to issue the following interim directions. 1I, the 8,505 officers whose list has been and while reiterating our directions issued on 19th January 2026, we deem it appropriate to issue the following additional directions. 1I, let the state government ensure that all the 8,505 Group B officers whose list has been handed over today in court, report for duty to the district electoral officers, EROs, tomorrow by 5 p.m. The Election Commission of India shall have the discretion to replace the direction number 2. The Election Commission of India shall have the discretion of replacing the EROs, AEROs.
To use their services. To use their services.
No. First we have the replacement. Replacement of the existing EROs, AEROs, and utilize the services of the officers who have now been placed on deputation with the Election Commission of India.
If they are suitable.
If so,
Micro observers.
If the election
Not
commission
ERO,
is satisfied
micro observers.
with regard to their qualifications.
UROs are senior.
Placement of ERO or AERO only.
Essentially, EROs, millets. Millets, the problem is this. In the whole list, there are no SDOs, there are no SDMs. If they are all department clerks, etc., having seniority to have the grade. Millets, we will ask them if necessary, they have to provide.
Micro observers.
Well, 8,000 is the 8,000 micro observers. They are replacing the micro observers.
Out of the
Anybody is found suitable, millets.
Subject to their suitability for the quasi-judicial or semi-quasi-judicial responsibility. 3I, all the rest of the 8 officers, officials from the list of 8,505, the Election Commission, after brief scrutinization, after briefly scrutinizing their biodata or work experience may shortlist them equivalent to how many micro observer you have?
8,500.
Over 8,000.
We have got 6,500 minutes.
May shortlist these officers stroke officials equivalent to the strength of the micro observer already engaged. Mr. These state government officers stroke officials may be imparted a brief training of day or so for the purpose of providing assistance to the EROs stroke AEROs, along with micro observers who have already been engaged. Next paragraph. It is made clear that the responsibilities assigned stroke to be assigned to the micro observers or the state government officers stroke officials shall be only to assist the EROs stroke AEROs in the decision making process. In other words, and as rightly stated by Senior Counsel for the Election Commission of India, the decision will be taken by the final decision will be taken by the EROs only. Next paragraph. Since with the engagement of new set of government officers stroke officials for the purpose of scrutinizing the documents which have already been submitted and where even the hearings have also taken place. Shall we run through that? Since the process of scrutinizing the documents submitted by the affected persons in the response to notices served on them is likely to take more time, and as suggested on behalf of some of the petitioners, we direct that at least 1 week more time beyond 14th February 2026 will be granted to the EROs stroke AEROs for completing the scrutiny of the documents, and taking an appropriate decision. Next paragraph. As regard to so on behalf of the petitioners, a reference has been made to certain documents to suggest as if the micro observers are the final authority. This aspect has been clarified on behalf of the Election Commission of India that the micro observers as well as the government officers stroke officials who will be taken on board for assisting the EROs from tomorrow onwards shall only be assisting the prescribed statutory authority for the purpose of taking the final decision. Next paragraph. Mr. V.V. Giri, Senior Counsel in writ petition number so has pointed out. Mr. V. Giri, Senior Counsel in writ petition number so as well as London Solicitor General of India has referred to the counter affidavit.
Counter affidavit and additional affidavit.
Mr. Naidu, Senior Counsel for the ECI, have referred to the counter affidavit filed by the Election Commission of India in that petition. It is alleged in paragraph so and so that despite making complaints by the authorities of the Election Commission of India, no FIRs are being registered against the persons who are suspected to be involved in burning the reports of objection and or indulging in other alleged unlawful activities. Alleged burning or alleged unlawful activities.
Lords, I'm sorry to interrupt, my lords. We have responded in paragraph 10 to the state.
Just a minute, please.
Yes.
Though this is being strongly refuted by Dr. Menka Goswami, Lord Senior Counsel, representing the state of West Bengal in that petition, we are reminded of our order dated 19th January 2026, in which a categorical direction was issued to the Director General of Police, Superintendent of Police, and the collectors in the state of West Bengal to ensure the maintenance of law and order. We therefore showcase the Director General of Police to file his personal affidavit in response to the allegations made by the Election Commission of India in its counter affidavit in the cited petition. We make it clear that in case don't say anything. We will take a final call with respect to the powers of the Election Commission of India in this regard. But before doing so, we deem it appropriate to accord an opportunity to the Director General of Police to explain on his part. Next paragraph.
This one. Yes.
In relation to the documents,
persons to whom notices have been served shall be entitled to rely upon all or any one of the documents referred to by the Election Commission of India
in the SIR notice.
In the SIR notice, and all such documents shall be considered by the EROs while taking a final decision.
About order dated 9 January.
We are include the documents referred to in our order dated 19th January, all the documents, including those referred to in our order dated 19 January 2026, shall be considered by the EROs while taking a final decision, while passing order in response to, while passing order on the objections received in response to the notices served.
And the objections filed in Form 7 below. And the objections filed in Form 7.
To that extent, they will be wrong to say admit card. Admit card along with mother certificate. Then only it becomes relevant document.
Correct.
May I add one thing, Milord?
Lordships are extending the time for filing claims. Could your Lordships are extending the time for filing claims? Could your Lordship say claims stroke objections, my Lord? Because both go together.
Similarly, the ERO shall be duty bound to consider the objections, if any, received from the person as per the statutory scheme. As per the statutory scheme, whether or not such persons come forward for person hearing. It goes without saying that the genuineness of the documents filed along with these objections can be scrutinized, verified in the same manner as the documents to be submitted by the objectors to the submitted by the affected person. Affected persons.
Minutes.
Anything?
Item 42 maybe tagged to item 41. Item 42.
Millets, I need to add one sentence. Millets. Yes.
Objection is filed as non-citizen. That cannot be gone.
No, we will not.
Millets, may I add one thing?
Item 42 may be tagged with item 41.
I have 1 minute.
Within the
item 42 may be tagged to item 40.
An objection. Electors means within that constituency.
Millets, may I just say for one
not
thing.
From other constituency. statute makes such a provision that electors only, my lord, kindly see, my lord.
My lord, item 42.
This will be considered.
My lord, kindly hear that, my lord, objectors.
May I just have 1 minute?
Objectors only
lords
can be
have
the
indicated
electors. Electors
the
of that
top-ranked police
constituency,
officer must file an
not from the other constituency.
The top-ranked
That
police
is under the
officer,
act itself.
Any elector.
the top-ranked police officer must file an affidavit.
Any elector
My
of
lords have
that
directed
constituency. I am
in the
saying that
context of my counter.
Words, that constituency.
My lords, counter and additional counter, because we have stated in the additional counter, all the subsequent events also. Counter and additional.
State has also filed
This is
counter.
additional affidavit.
In
Additional affidavit.
40.6, my lords, the state has also
Millets.
filed a counter
The
affidavit.
second thing, Millets, there are instances that they are under deputation to me. Some erring officials were there. We have pointed out, we have taken action, we have recommended that should be implemented. That's not been implemented. They should implement whatever we
That will not be a
wanted.
landlord, bro. That will be the state, that civil administration.
Millets,
The EROs may not
where they
decide
refuse.
uninfluenced by any of these
Millets-
observations and
Millets, they
directions.
have asked certain officers who have acted illegally to be placed under suspension. They have simply ignored. And on the other hand, when we wanted certain officers to be on the duty, they have transferred, though they are under my deputation.
Mr. Pant, you verify this fact.
Yes, Millets. And the last one, Millets, and the last one. My lords have said those documents have to be verified in the manner permitted by law. Documents issued by the competent authorities.
That's it.
That's all
Yes.
we want.
That's it.
That needs to be issued by competent authority, otherwise that leads to conflict.
Obviously, otherwise somebody will. ask
Yes, Millets, anybody,
right, a surplus
yes.
right, that
This is the ECI requirement.
My lord, intervention application.
I would respectfully submit the EROs to decide uninfluenced. my lord.
To place some officers to take display action or to place them under suspension. We hope that your state government remember the law on this point and you take.
Given instances.
Sir, we have already responded.
Let
to
Chief Secretary also filed an affidavit.
Given instances, not
We have-
very, very.
In any case, you relieve those officers from duty.
We'll do that, Millets. We'll take it to our hands and do something.
The election commission जहाँ पे है ना, shall be at liberty to replace the officers who have been found, who have been prima facie found to have erred in performing their duties.
My lord, on the
Deeply
intervention
But
application.
would your lordship observe that the EROs are to decide uninfluenced by any of these?
Said so. Yeah, but in
You remember that PPT, Velas, where
we are
PPT
twice
academic
they are
exercise in
only-
training.
They will only.
Millets,
No, but
PPT
this
is
applies-
Item 42 may be tagged item 40, my lord.
It is
Identical matter.
is by ECI.
Item 42 may be tagged with.
Let's go.
My lord, in item 40.2, my lord, notice may be issued on the.
Well, item 42 may be tagged with item 40, my lord. Item 42 on same point, can tag with item 40, my lord. Item 42, I have raised a question on the other card, my lord. 42, well, can you tag with 40, my lord?
Will,
My point is, my point is, somewhere.
the speed with which all these West Bengal writ petitions are coming, I will issue the registry instruction not to entertain any.
My point is, my Justice Bhakti said me that my point is covered. I have some other point.
Sir, can you hear me?
Item 32, my lord, can I mention something else?
State of West Bengal is itself is before us. This constitutional umbrella is before.
But this point has not been taken, my lord. This point has not, my point is very short, my lord. During submission of my claim that the electoral officers cannot, my lord, upload the other card as a single document. This is my point.
All right, thank you very much. Thank you very much.
But item 40
Can I mention, my lord, one matter? Item 32.
Item
Lord,
32.
item 32 is that matter of the hospital where we want to lay the road,
Thank God you are
approach
not
road.
West Bengal election.
Well, kindly 42 may tag with item 40, my lord.
32, what is 32?
Lord, can it be on Monday high up on board, my lord, if your lordship can?
For the hospital.
Lord, item 28 is for settlement.
Kindly keep it high up, my lord, on Monday.
32, Mr. Mehta, you want next Monday?
Yes, my lord, because entire hospital is ready, but we are operating only on OPD because ambulance approach road is not constructed.
Yes, sir, number.
Lord, item 28,
Yes, sir, number one, next Monday.
Lord, item 28 is
Well,
settlement.
kindly tag it.
All
Kindly 42 tag.
show date. That show date will be running between this very week by Monday adjust to them.
Lordship, please.
Kindly tag it, my lord, 42. Kindly 42, item 42 with 40, only tag it, my lord. So identical issues, my lord, there.
We have tagged, sir, we are hearing your matter also.
Can you, within 40, I want to come within 40, my lord.
I have heard you also today, please.
Yes, my lord. Can you agree 40, my lord?
Next date again, we will hear you.
My item number 48.
Item number 48, my lord.
Really?
Item number 48. We are not against.
Those who have not been able to exhaust today, we will exhaust them next day.
Good night, Your Lordship.